Report of investigation of former Federal Bureau of Investigation Director James Comey's disclosure of sensitive investigative information and handling of certain memoranda. Oversight and Review Division 19, the 2nd of August 2019. Introduction. This report describes the investigation by the Department of Justice (DOJ) or Department Office of the Inspector General (OIG) into the creation, storage, and handling of certain memoranda memos written by former Federal Bureau of Investigation (FBI) Director James B. Comey. Between January 6, 2017, and April 11, 2017, while Comey was director of the FBI, he memorialized 7 one-on-one interactions that he had with President-elect and President Donald J. Trump. 1. Throughout this report, these memos are referred to as Memo 1 through Memo 7, numbered chronologically according to the date each memo was written. Comey, who had original classification authority as FBI director, marked a small amount of information in Memo 1 as classified at the time that he wrote it. Comey also believed that Memo 3 contained classified information when he wrote it but did not mark the document as classified. Comey kept signed originals of Memos 2, 4, 6, and 7 in a personal safe in his home and, following his May 2017 removal as FBI director, provided his personal attorneys with copies of Memos 2, 4, and 6, and a redacted version of Memo 7. Comey never took copies of Memos 1, 3, and 5 to his home, and never shared these memos with anyone outside the FBI. In June 2017, following Comey's removal as FBI director, the FBI reviewed the memos to determine if any of the memos contained classified information. The FBI determined that Memos 1 and 3 contained information classified at the secret level, and that Memos 2 and 7 contained small amounts of information classified at the confidential level. The FBI designated Memos 4, 5, and 6 as unclassified, for official use only. This matter was referred to the OIG for review in July 2017 by then-acting FBI Director Andrew G. McCabe, consistent with department regulations and the Inspector General Act, after the FBI determined that Comey may have shared with his attorneys memos that contained classified information. At the time, the OIG also was aware of Comey's June 8, 2017 congressional testimony that he had authorized a friend, who was also one of his personal attorneys, to provide the contents of Memo 4, which did not contain any classified information, to a reporter for the New York Times. The focus of the OIG's investigation was to determine whether Comey violated department or FBI policies, or the terms of his FBI employment agreement, in his handling of the memos during and after his tenure as FBI director. The OIG's investigation included review of the memos as well as numerous additional documents, emails, and news articles, and forensic analysis of certain computer systems. As part of this investigation, the OIG also interviewed 17 witnesses, including former Director Comey and Daniel Richman, the individual who, at Comey's request, shared the contents of one of the memos with a reporter for the New York Times. Through our investigation, we learned that Comey considered Memos 2 through 7 to be his personal documents. He created Memo 2 and Memo 4 on his personal laptop computer, and kept signed originals of 4 of the memos, Memo 2, Memo 4, Memo 6, and Memo 7, in his personal safe at home, while he was serving as FBI director. He also generated a duplicate set of originals of Memos 2 through 7 for his Chief of Staff, James Rybitsky, to maintain at the FBI. When Comey was removed as FBI director on May 9, 2017, Comey still had copies of Memos 2, 4, 6, and 7 in his personal safe at home. After being removed as director, Comey did not report to the FBI that he had copies of these memos. Comey subsequently provided his copies of Memos 2, 4, 6, and 7 to the Office of Special Counsel Robert S. Mueller III on June 7, 2017. 2. On May 14, 2017, Comey used his personal scanner and private email account to provide electronic copies of Memos 2, 4, 6, and 7 to one of his personal attorneys. 3 days later, on May 17, that attorney provided, via personal email account, copies of these 4 memos to 2 other attorneys, who were also part of Comey's legal team. Of the memos Comey shared with his attorneys, Memo 2 contained 6 words that the FBI determined in June 2017 to be classified at the confidential level. 3 memos 4 and 6 contained information that the FBI determined in June 2017 to be for official use only, but did not contain classified information, and Memo 7 was redacted by Comey before transmission, which obscured the information in Memo 7 that the FBI determined in June 2017 to be classified. Comey did not seek authorization from the FBI before providing Memos 2, 4, 6, and 7 to his attorneys. On May 16, 2017, Comey provided a separate copy of Memo 4 to Richmond, who was one of Comey's attorneys and also a close personal friend. Richmond also had served as a special government employee at the FBI during a portion of the time that Comey was FBI director. Comey sent photographs of both pages of Memo 4 to Richmond via text message from Comey's personal cell phone. Comey instructed Richmond to share the contents of Memo 4, but not the memo itself, with a specific reporter for the New York Times. Comey did not seek FBI authorization before providing the contents of Memo 4, through Richmond, to a reporter. As noted above, the FBI later marked Memo 4 for official use only, and determined that it did not contain classified information. We found no evidence that Comey or his attorneys released any of the classified information contained in any of the memos to members of the media. Upon completing our investigation, pursuant to Section 4(d) of the Inspector General Act of 1978, the OIG provided a copy of its factual findings to the Department for a prosecutorial decision regarding Comey's conduct. See 5 U.S. C. A. App. 3 Section 4(d) 2016. After reviewing the matter, the department declined prosecution. Thereafter, we prepared this report to consider whether Comey's actions violated Department or FBI policy, or the terms of Comey's FBI employment agreement. As described in this report, we conclude that Comey's retention, handling, and dissemination of certain memos violated Department and FBI policies, and his FBI employment agreement. Point 4. 2. Relevant statutes and policies. A. Federal records and official information. The statutory definition of federal records is broad, and includes all recorded information, regardless of form or characteristics, made or received by a federal agency under federal law or in connection with the transaction of public business, and preserved or appropriate for preservation by that agency as evidence of the organization, function, policies, decisions, procedures, operations, or other activities of the United States government, or because of the informational value of data in them. 5. This definition includes any act of creating and recording information by agency personnel in the course of their official duties, regardless of the methods or the medium involved. 6. Working files, such as preliminary drafts or notes, may also qualify as official agency records if they were circulated or made available to other employees for official purposes, and contain unique information that assists in the understanding of an agency's policies, decisions, or actions. Point 7. Department and FBI policies address what qualifies as a federal record and describe employee responsibilities regarding federal records. Point 8. The department's policy states that LLDOJ employees are responsible for maintaining the information they generate, receive, or review while conducting departmental business in accordance with departmental and component policies. 9. The FBI's policy includes in the definition of a record any items that document or explain the basis of a significant action or decision involving the exercise of government authority, or items necessary to document other significant operations or administrative matters. 10. The Department and the FBI follow specific guidance provided by the National Archives and Records Administration (NARA) for permanent retention of materials of senior officials, also known as capstone officials. NARA approves the records management program for capstone officials, of which the FBI director is one. This program designates which documents are considered official federal records, and provides specific records retention schedules for such capstone officials. 11 The records retention schedule for FBI senior executives states that the FBI must maintain, as official FBI records, the emails, personal notes, annotated briefings, not maintained elsewhere, and other documentation received or generated by the director in the normal course of business. Emphasis added. 12 In contrast, federal regulations define personal files or records as documentary materials belonging to an individual that are not used to conduct agency business. 13 Merely labeling a document as personal or private does not alter the official nature of a document if it is used in the transaction of public business. 14 The FBI's records management policy adds that personal papers are materials not used to conduct FBI business that are primarily personal in nature. 15 Documents containing both personal and official information must be treated as a federal record. 16 Department and FBI policies require that employees use officially approved Department or FBI information technology systems to process, store, and transmit official information. 17 There are very few exceptions to this rule. For example, FBI employees may use non-FBI systems such as GPS to navigate, personal devices to locate colleagues during an emergency, or personal devices to check official emails through an FBI-sponsored secure web page. 18 Department policy states that employees may not, without agency permission, remove records from the department, either during or after employment. 19 Under department policy, the only items that departing employees may remove without prior approval or personal information are documents that are unrelated to the department and official business, copies of any unclassified information already officially in the public domain, and copies of the employee's email contacts. 20 A departing employee must make a written request, receive approval from the appropriate official, and execute a non-disclosure agreement before removing any records or information. 21 Before authorizing any such request, the approving official must ensure that the requested documents do not contain any prohibited categories of information, such as classified information. 22 According to department policy, if the head of a department component, for example, the FBI director, seeks to remove department information, he must receive approval from the Assistant Attorney General for Administration. 23 The FBI policies are no different. When FBI employees separate from the FBI, they are required to surrender all materials in their possession that contain FBI information. 24 Every employee signs an FBI employment agreement at the beginning of their employment acknowledging this requirement. According to one section chief of the FBI's Records Management Division (RMD), this requirement covers all FBI information, whether it's a record or not, created or gotten by access or acquired during the course of their employment. It is property of the U.S. government. B. Disclosure of FBI information for non-official use purposes pursuant to FBI policy. All information acquired by FBI personnel in connection with official FBI duties, as well as all official material to which FBI personnel have access, is the property of the United States. 25 Accordingly, before disclosing FBI information outside of the FBI for non-official purposes, current or former FBI personnel must obtain, with limited exceptions such as for whistleblowing and disclosures to Congress, advanced permission from the FBI. 26 This policy applies to any type of disclosure, whether oral, written, or electronic. 27 FBI employees agree to be bound by this requirement when they sign the FBI employment agreement. In evaluating requests from current or former FBI employees to release FBI information for non-official purposes, the FBI reviews the proposed disclosure to ensure, among other things, that it does not include information that is classified, related to an ongoing investigation, are covered by the Privacy Act of 1974, 5 U.S. C. Section 552A.28. C. Department and FBI Policies on Disclosure of Information about Pending Investigations. Section 3.4 of the FBI's then existing policy on media relations stated that disclosures to the media must not address an ongoing investigation, except as indicated in that section. 29. The section provided two examples of when it may be permissible to selectively release non-classified information to assure the public that an investigation is in progress, with prior approval of specific components at FBI headquarters. 1. To protect the public interest, welfare or safety. 2. To solicit information from the public that might be relevant to an investigation. Section 3.3 of the FBI policy also provided that all releases must be consistent with all applicable laws and regulations and policy, including the then-existing United States Attorney's Manual, USAM, Title 1 to 7.000, Media Relations. 30. Title 1 to 7.000 of the USAM established specific guidelines for the release of information relating to criminal and civil cases by the FBI and other department components. Among other things, Section 1 to 7.530 of the USAM provided that a. Except as provided in subparagraph B of this section, components and personnel of the Department of Justice shall not respond to questions about the existence of an ongoing investigation or comment on its nature or progress, including such things as the issuance or serving of a subpoena, prior to the public filing of the document. B. In matters that have already received substantial publicity, or about which the community needs to be reassured that the appropriate law enforcement agency is investigating the incident, or where the release of information is necessary to protect the public interest, safety or welfare. Comments about or confirmation of an ongoing investigation may need to be made. In these unusual circumstances, the involved investigative agency will consult and obtain approval from the United States Attorney or Department division handling the matter prior to disseminating any information to the media. Comey told the OIG that, during his tenure as FBI director, the authority to disclose the existence of a pending investigation was confined to the director and the deputy director, and that in making such decisions, the default was, "We don't talk about pending investigations." The statutes, regulations, and policies regarding classified information in documents designated for official use. Only current and former FBI employees have an ongoing responsibility to protect any classified information to which they are given access during the course of their employment. Executive Order 13,526 sets forth a uniform classification system to prevent access by unauthorized persons, ensure the integrity of the information, and provide a standardized marking system across the executive branch to facilitate the use and sharing of classified information. 31. The system applies to all information owned by, produced by or for, or under the control of the United States government. 32. FBI employees must adhere to the policies promulgated by the intelligence community, the department, and the FBI that implement this executive order. Federal employees may only have access to classified information if they have a current security clearance, have signed a non-disclosure agreement (NDA), and have a need to know the classified information to carry out official duties. 33. Once granted access to classified information, authorized employees must properly handle it, protect it from unauthorized disclosures, and properly secure it in approved location. 34. Likewise, FBI employees working with or discussing classified information must process, transmit, and store such information only on authorized systems and in approved facilities. 35. Information is eligible for classification only if it falls into one of the categories listed in Executive Order 13,526, which include intelligence activities, sources and methods, and foreign relations or foreign activities of the United States. 36. There are three basic levels for classified information, each based on the amount of harm unauthorized disclosure of the information could reasonably be expected to cause to national security. 37. Information is classified, top secret, which is the highest level, if its unauthorized disclosure reasonably could be expected to cause exceptionally grave damage to national security. 38. For information classified, secret, The standard as reasonably could be expected to cause serious damage to national security, while for confidential information, the lowest level, the standard as reasonably could be expected to cause damage to national security. 39. In addition to the basic levels of classification, there are several dissemination controls which restrict the distribution of a classified document. The designation NOFORN, or No Foreign Nationals, means that the document cannot be provided to any foreign nationals. 40. ORCON, or Originator-Controlled, means that the document may not be provided to anyone without the express permission of the official or agency that originally drafted it. 41. Some unclassified documents are subject to the FOUO dissemination control, which means they are for official use only. This marking is for unclassified official government information that is withheld from public release until approved for release by the originator. 42. FBI guidance sets forth additional instructions for the use of the FOUO designation, limiting its use to information such as personnel files, items exempted from public release by statute, and materials that would only be discoverable during litigation against the agency. 43. In addition, FBI policies include specific requirements for the manner of storage and processing of FOUO information to prevent disclosure to anyone without a need to know. 44. Federal employees who are designated as original classification authorities (OCAs) bear the responsibility for determining, in the first instance, whether to classify information owned by, produced by, or for, or under the control of the United States government. 45. NOCA's authority flows from the President of the United States through agency heads, and Executive Order 13,526 directs agencies to maintain only a small number of OCAs. 46. The FBI has 16 OCAs, including the Director, Deputy Director, General Counsel, and the Assistant Directors of certain FBI divisions, such as the Counterintelligence Division. These OCAs receive annual training, including avoidance of overclassification, instruction on the proper safeguarding of classified information, and on the sanctions that may be brought against an individual who fails to classify information properly or protect classified information from unauthorized disclosure. 47. Within the FBI, OCAs may only make classification decisions for information within the programs they oversee. 48. OCAs must document their classification decisions in writing, by either marking specific documents individually, which the FBI notes as rare, or by specifying the categories of classified information in a classification guide. 49. FBI employees who author classified documents must also properly mark the documents. 50. Federal Regulations, Intelligence Community Guidance, and FBI policies require classified documents to contain several types of markings, classification headers and footers on each page of the document, individual portion or paragraph markings, i.e. the abbreviations and parentheticals at the beginning of paragraphs, and a classification authority block, which identifies who classified the document, the basis for the classification, and the declassification date after which release of the information no longer presents a danger to national security. 51. The FBI's Safeguarding Classified National Security Information Policy Guide also requires that a NY person who has knowledge that classified information has been or may have been lost, compromised, or disclosed to an unauthorized person must immediately report the circumstances to his or her security office. 52. The Federal Criminal Code contains statutes addressing the mishandling or release of classified information. 53. For example, 18 U.S. C. Sections 793 D and F are felony statutes regarding the mishandling of classified information relating to the national defense. Title 18 U.S. C. Section 793 D applies to individuals who have authorized access to such information, and willfully communicate, deliver, or transmit it, or cause it to be communicated, delivered, or transmitted to individuals who are not entitled to receive it. Section 793, F1, addresses the removal, delivery, loss, theft, abstraction, or destruction of such information through gross negligence of the individual entrusted with it. Section 793, F2, penalizes the failure to report the removal, loss, theft, abstraction or destruction of information relating to the national defense if an individual has knowledge that it has been removed from its proper place of custody. As indicated above, the OIG provided a copy of its factual findings to the department for a prosecutorial decision. After reviewing the matter, the department declined prosecution. 3. Timeline of relevant events. January 6, 2017. Intelligence Community Directors, including Comey, meet with President-elect Trump and his national security team at Trump Tower to discuss the intelligence community assessment. Comey then meets with the President-elect one-on-one to alert Trump to salacious or unverified allegations about his 2013 trip to Moscow that the media may soon publish. January 7, 2017. Comey finishes drafting Memo 1 on the FBI's secure computer system about the Trump Tower briefing and marks Memo 1 with the classification, secret, NOFORN, or CON. Comey emails Memo 1 to his Chief of Staff, the FBI Deputy Director, and the FBI General Counsel using the FBI's secure computer system. Comey does not take a copy of Memo 1 home. January 27, 2017. Comey has dinner with President Trump at the White House. January 28, 2017. Comey finishes writing Memo 2 on his personal laptop about his dinner the night before with President Trump. It states that during dinner, among other things, Trump told Comey he needed and expected loyalty. Memo 2 also describes an unrelated comment by the president about the relative importance of returning telephone calls from 3 different countries, one of which the memo notes the president mentioned twice. Comey does not mark Memo 2 as classified. Comey places a signed printout of Memo 2 in his personal safe at home and gives a second signed printout to his chief of staff to keep at the FBI. During a classification review in June 2017, the FBI determines that 6 words in the memo recounting the president's comment about returning telephone calls are classified, confidential, NOFORN, because of the potential impact on foreign relations. February 8, 2017. Comey writes Memo 3 on a classified FBI computer system because he believes Memo 3 contains classified FISA information. Memo 3 summarizes Comey's interactions that afternoon with Trump's then Chief of Staff Reince Priebus, then National Security Advisor Michael Flynn, and President Trump. Comey does not mark the printout of Memo 3 as classified before sharing it with others at the FBI. Comey does not take a copy of Memo 3 home. The FBI determines in June 2017 that Memo 3 contains information classified as secret, NOFORN. February 14, 2017. Comey writes Memo 4 on his personal laptop describing, among other things, a one-on-one meeting that day with President Trump. According to Memo 4, Trump stated that he hoped Comey could see his way clear to letting Michael Flynn go. At the time, Flynn was the subject of a non-public FBI investigation. Comey does not mark Memo 4 as classified. Comey places one signed printout of Memo 4 in his personal safe at home and gives a second signed printout to his Chief of Staff to keep at the FBI. The FBI determines in June 2017 that Memo 4 does not contain classified information, but marks it as FOUO. March 1, 2017. Comey drafts Memo 5, a 4-line email to his Chief of Staff, on his unclassified FBI mobile device to summarize a non-substantive telephone call that day with President Trump. Comey does not mark Memo 5 as classified, and does not take a copy of Memo 5 home. In June 2017, the FBI determines it is not classified, but marks it as FOUO. 11. March 20, 2017. Comey testifies before the House Permanent Select Committee on Intelligence (HPSCI) at a hearing titled The Russian Active Measures Investigation. Comey acknowledges the FBI's open investigation into Russian interference in the 2016 presidential election, but repeatedly refuses to answer questions about the scope of the investigation or specify who was under investigation. Referencing the need to protect the integrity of the investigation and the privacy rights of those under investigation. March 30, 2017, Comey writes Memo 6 on the unclassified FBI system in his office to describe a 10-minute telephone call with President Trump that morning. According to the memo, Trump asked what Comey could do to lift the cloud of the FBI's Russia investigation. Comey gives a signed printout of Memo 6 to his chief of staff to keep at the FBI, and takes a second signed printout home to store in his personal safe. Comey does not mark Memo 6 as classified. In June 2017, the FBI determines that Memo 6 is not classified, but marks it as FOUO. April 11, 2017, Comey drafts Memo 7, a two-paragraph memo on the unclassified FBI system in his office to summarize a brief telephone call with President Trump that morning. According to the memo, Trump said he was following up to see if Comey did what Trump had asked last time, getting out that Trump is not personally under investigation. Paragraph 2 of Memo 7 summarizes an unrelated foreign policy discussion. Comey signs two printouts of Memo 7. Comey gives one to his chief of staff to keep at the FBI, and he stores the other in his personal safe at his house. Comey does not mark Memo 7 classified, but is described below, redacts the second paragraph of Memo 7 before sending it to his attorneys on May 14. The FBI determined in June 2017 that the second paragraph of Memo 2 contained presidential comments about foreign affairs that are classified, confidential, NOFORN. May 9, 2017, President Trump removes Comey as FBI director and orders that Comey be barred from entering FBI headquarters. May 11, 2017, The New York Times publishes an article regarding the January 27 dinner meeting described in Memo 2, stating that Trump asked for Comey's loyalty. Richmond acknowledged that he was the source for the article, and that Comey had described to him what Comey said was President Trump's request for loyalty at the dinner. At that time, Richmond had not yet seen Memo 2. 12. May 12, 2017, President Trump tweets about the possible existence of tapes of his conversations with Comey. May 14, 2017, Comey sends scanned copies of Memos 2, 4, 6, and 7 from his personal email account to the personal email account of one of his attorneys, Patrick Fitzgerald. Before sending, Comey redacts the second paragraph from Memo 7 involving foreign affairs because Comey deems it irrelevant. On May 17, Fitzgerald forwards these four memos to Comey's other attorneys, David Kelly and Richmond. May 16, 2017, Comey sends a digital photograph of Memo 4, describing the meeting in which Comey wrote that President Trump made the statement about letting Flynn go, to Richmond via text message from Comey's personal phone. Comey asks Richmond to share the contents, but not the memo itself, with a specific reporter for the New York Times. Comey's stated purpose is to cause the appointment of a special counsel to ensure that any tape recordings that may exist of his conversations with President Trump are not destroyed. Richmond conveys the substance of Memo 4 to the reporter. The New York Times publishes an article entitled, Comey Memo Says Trump Asked Him to End Flynn Investigation. May 17, 2017, Deputy Attorney General Rod Rosenstein appoints Robert S. Mueller III as special counsel. June 1–6, 2017, FBI conducts a classification review of Comey's memos. The FBI determines that Comey correctly classified Memo 1, which Comey did not share with anyone outside the FBI, that Memos 4, 5, and 6 are unclassified but FOUO, and that portions of Memos 2, 3, and 7 are classified. As follows: Memo 2, 6 words from a statement by President Trump comparing the relative importance of returning telephone calls from 3 countries, one of which the memo notes the president mentioned twice, are classified as confidential, NOFORN. Comey did not redact this information before sharing Memo 2 with his attorneys. Memo 3. Information about sources, methods, investigative activity, and foreign relations is classified as secret, NOFORN. Comey did not share Memo 3 with anyone outside the FBI. 13. Memo 7. An assessment of a foreign leader by President Trump and discussion of foreign relations is classified as confidential, NOFORN. Comey redacted this paragraph before he sent Memo 7 to his attorneys. June 7, 2017. Comey reviews the FBI's marked copies of all 7 memos in preparation for his congressional testimony. Comey returns to the FBI the unmarked copies of Memos 2, 4, 6, and 7 that he had kept at his home, but does not tell the FBI that he sent copies of Memos 2, 4, 6, and 7 to his 3 attorneys. June 8, 2017. Comey testifies to Congress that he shared a copy of one memo regarding letting Flynn go. Memo 4, with a friend, Richmond, with instructions that the friend share the contents with a reporter. The FBI has multiple telephone calls with Richmond over the next several days and learns from Richmond, on or before June 9, that he and Comey's other 2 attorneys also have copies of 3 other memos. June 13, 2017. FBI begins the process of recovering or deleting the memos from the computer systems of Richmond, Fitzgerald, and Kelly, a process that is completed in January 2018. IV. Factual findings. A. Background facts. 1. Comey's professional background. Comey received a law degree from the University of Chicago Law School in 1985 and held a number of positions within the department prior to being appointed FBI director. Early in his career, from 1987 to 1993, Comey served in the office of the U.S. Attorney for the Southern District of New York, where he was promoted to Deputy Chief of the Criminal Division. From 1996 to 2001, Comey served as the Managing Assistant U.S. Attorney in charge of the Richmond Division of the U.S. Attorney's Office for the Eastern District of Virginia. Starting in January 2002, Comey served as the U.S. Attorney for the Southern District of New York, a position he held until December 2003, when Comey was appointed Deputy Attorney General for the Department of Justice. Comey served as Deputy Attorney General until 2005, after which he worked in the private sector. In 2013, Comey was nominated by then-President Obama to serve as FBI Director and was confirmed by the Senate to serve a 10-year term. On May 9, 2017, Comey was removed from his position as FBI Director by President Trump. 14. 2. Terms of Comey's FBI employment agreement. As a condition of his employment as Director of the FBI, Comey signed an FBI employment agreement, through which he agreed to be governed by a number of provisions, including an acknowledgement that all information acquired by him in connection with his official duties and all official material to which he has access to remain the property of the United States. An agreement to surrender, upon separation from the FBI, all materials containing FBI information in his possession. A commitment not to reveal, by any means, any information or material from or related to FBI files or any other information acquired by virtue of his official employment to any unauthorized recipient without official written authorization by the FBI. An agreement to seek determination whether information may be disclosed prior to any disclosure, using the guidelines found in the FBI Manual of Administrative Operations and Procedure. An agreement to be bound by the FBI's guidelines governing per-publication review, with the understanding that the term publication includes the disclosure of information to anyone by any means, and an acknowledgement that these provisions are conditions of employment and apply both during his employment in the FBI and following termination of such employment. In his interview with the OIG, Comey verified his signature on his FBI employment agreement. 3. Comey's security clearance history. Throughout Comey's employment at the Department of Justice, including his tenure as FBI Director, Comey held security clearances that provided him access to classified information pursuant to non-disclosure agreements, NDAs. Under the terms of these NDAs, Comey acknowledged that he had been advised about the nature of a need to protect classified information. and agreed to never divulge classified information to anyone not authorized to receive it unless Comey had obtained prior written authorization for the disclosure from the U.S. government department or agency responsible for the classification. The NDAs that Comey signed clearly stated that any unauthorized disclosure of classified information by me may constitute a violation, or violations, of United States criminal laws, and the NDAs referenced 18 U.S. C. Section 793 and 18 U.S. C. Section 1924, among other provisions. Pursuant to the NDAs, Comey also agreed that if he was uncertain about the classification status of information, it was his responsibility to consult with appropriate officials for clarification. The NDAs also stated that all of the classified information provided to Comey during his employment, it is now and will remain the property of the United States government unless and until otherwise determined by an authorized official or final ruling of a court of law. Further, Comey agreed to return all classified materials upon the conclusion of my employment, and acknowledged that his obligation to protect classified information applied during his employment and at all times thereafter. During his OIG interview, Comey verified his signature on a number of NDAs he had signed during his tenure as FBI director and at other times while employed by the U.S. government, and told the OIG he was aware of his obligations to protect classified information under those agreements. He also acknowledged that he had an obligation, lifelong, to protect classified information. 4. Comey's status as an original classification authority and responsibility for designating classified material as FBI director. Comey was one of the officials designated by the FBI as an original classification authority, OCA. Comey's FBI training records show that he received initial training on his responsibilities as an OCA on January 9, 2014, and annual training most recently on March 28, 2017. Comey told the OIG that, during his tenure as FBI director, it was often the case that he was reviewing reports that had a known classification, or replying to emails that had been classified by others. 54 He said that the amount of his written work as FBI director that involved exercising his OCA responsibility was a distinct minority. Other FBI witnesses confirmed that while he was FBI director, Comey did not generate a lot of documents that required marking through use of his original classification authority. Comey told the OIG that the essence of being an OCA is exercising a judgment about the appropriate level of classification for the information, and that in making such a judgment call, he used his experience and knowledge of the content of the document he was creating to make the best judgment he could about the level of harm that might flow from unauthorized disclosure of the information. He also acknowledged that, as FBI director, here were plenty of people he could ask if he wanted to, and that the resources would be available to him to make those determinations, although he told the OIG he did not remember ever using those resources. B. Comey's creation and handling of the memos from January 6, 2017 through May 9, 2017. Comey told the OIG that from January 6, 2017, through his removal as FBI director on May 9, 2017, he had a total of 9 one-on-one conversations with President-elect and President Trump. For 7 of the 9 conversations, Comey said he created written records, which are collectively referred to throughout this report as the memos. 55. 1. January 7, 2017 memo. Memo 1. Comey's first one-on-one meeting with Trump occurred on January 6, 2017, at Trump Tower as part of a briefing to the president-elect on an intelligence community assessment of Russian efforts to interfere in the 2016 presidential election. The ICA was jointly prepared by the FBI, National Security Agency, NSA, and Central Intelligence Agency, CIA, with oversight from the Office of the Director of National Intelligence, ODNI. 56 According to Comey, the plan for the ICA briefing of President-elect Trump had 2 parts, both of which Comey said he was concerned would be controversial and difficult conversations. The first part of the briefing, jointly conducted by the intelligence community directors, involved briefing the president-elect on the overall conclusions of the ICA The second part of the briefing concerned notifying the president-elect of salacious or unverified information about Trump's alleged conduct in Moscow several years earlier. Prior to the January 6, 2017 briefing, the FBI learned that several media outlets also had this information, and were intending to publish it. Multiple witnesses told the OIG that the intelligence community directors agreed that Trump must be briefed on this information, and that the Director of National Intelligence (DNI) decided the briefing should be done by Comey, in a small group or one-on-one. Before briefing President-elect Trump, Comey met with senior leaders of the FBI, including his Chief of Staff James Rybitsky, then FBI Deputy Director Andrew McCabe, then FBI General Counsel James Baker, and the supervisors of the FBI's investigation into Russian interference with the 2016 presidential election. Baker and McCabe told the OIG that they raised and discussed with Comey a number of concerns about Comey meeting alone with President-elect Trump. Baker and McCabe said that they agreed that the briefing needed to be one-on-one, so that Comey could present the salacious information in the most discreet and least embarrassing way. At the same time, we were told, they did not want the president-elect to perceive the one-on-one briefing as an effort to hold information over him like a Hoover-esque type of plot. Witnesses interviewed by the OIG also said that they discussed Trump's potential responses to being told about the salacious information, including that Trump might make statements about, or provide information of value to, the pending Russian interference investigation. That FBI counterintelligence investigation, known as Crossfire Hurricane, concerned whether individuals associated with the Trump campaign during the 2016 presidential election were coordinating with, or had been unwittingly co-opted by, the Russian government. Multiple FBI witnesses recalled agreeing ahead of time that Comey should memorialize his meeting with Trump immediately after it occurred. Comey told the OIG that, in his view, it was important for FBI executive managers to be able to share in Comey's recall of the salient details of those conversations. Comey also said that an additional concern, shared by the members of his management team, was that if the briefing became a source of controversy, it would be important to have a clear, contemporaneous record because Trump might misrepresent what happened in the encounter. McCabe told the OIG that, in his view, it made sense for Comey to capture his contemporaneous recollection, because there were millions of ways that the FBI could get follow-up questions or criticism, and Comey wanted to recollect exactly, from his perspective, how it had taken place. Comey told the OIG he began writing Memo 1 immediately following his meeting with Trump on January 6, 2017. Comey said he had a secure FBI laptop waiting for him in his FBI vehicle, and that when he got into the vehicle, he was handed the laptop and began typing Memo 1 as the vehicle moved. He said he continued working on Memo 1 until he arrived at the FBI's New York field office, where Comey gave a quick download of his conversation with President-elect Trump to Rybitsky, McCabe, Baker, and supervisors of the FBI's Crossfire Hurricane investigative team via Secure Video Teleconference (SVTC). Comey said he probably told the SVTC participants that he would send them his detailed notes of the interaction. Comey told the OIG he could not remember whether he completed Memo 1 on January 6, 2017, or whether he continued drafting it on January 7, 2017, before sending it through the FBI's classified email system to Rybitsky, McCabe, and Baker on January 7, 2017 at 1:42 p.m. M.57 Memo 1 documented both the larger discussion of the ICA with the president-elect's national security team regarding Russian interference in the 2016 presidential election, and the one-on-one meeting that followed between Trump and Comey concerning the salacious information. Memo 1 was the only one of the memos on which Comey placed any classification, dissemination controls, or other handling markings. Comey placed an overall classification marking of secret, or con, NOFORN, at the top and bottom of the email. He also placed the following classification block before the substantive text of the email: classified by Director, derived from FBI NSIC, dated 2,013,030,158, declassify on 20,271,231 in the email's introductory note. Comey also wrote, "I am not sure of the proper classification here, so have chosen secret. Please let me know if it should be higher or lower than that." Comey told the OIG that he classified Memo 1 in this way because his judgment was that the information ought to be treated like FISA-derived information or information in a counterintelligence investigation, the standard classification for which is secret or CON-NOFORN. According to Comey, said he did not remember any of the email recipients responding to his question about whether Memo 1 should be classified at a higher or lower level. Comey also said he did not keep a copy of Memo 1 for himself, did not take a copy to his home, and did not share it with anyone other than the recipients listed on the email. He also told us he did not remember giving instructions to anyone to preserve Memo 1 or share Memo 1 with anyone else, and to his knowledge Memo 1 had not been shared outside the FBI. 59 Comey told the OIG that at the time he created Memo 1, it wasn't his plan to write a memo every time he had any meeting with President Trump. Comey said that, after that first meeting, he was optimistic that I wasn't going to have any further encounters with the president that were up close and personal. Baker told the OIG that based on his experience as FBI General Counsel, one-on-one meetings were quite outside the norm of interactions between the FBI Director and a President of the United States. 2. January 11, 2017 telephone call, no memo. Comey's second one-on-one interaction with President-elect Trump was a telephone call on January 11, 2017. Comey told us that, on that date, he received a call at approximately 1:30 p.m. from the President-elect's Chief of Staff, Reince Priebus. According to Comey, Priebus informed him that the President-elect would like to speak to you today. Comey told the OIG he did not remember there being any other substance to the call from Priebus. According to Comey, President-elect Trump called him at 5:00 p.m. that day. Comey told the OIG that he vividly remembered the conversation, during which they discussed a media report that had disclosed that salacious information, and Trump's concern about how that had been leaked. Comey said that, among other things, he remembered telling Trump that the source of the information was not a government document, and it's not classified. Comey also remembered telling Trump that to speak of it as a leak doesn't make sense, because a lot of people in Washington had the information, and Comey said he told Trump that he had previously warned Trump that it might soon be published by the media. Following the call, Comey told Rybitsky about the conversation in drafted and classified email to his administrative assistant, stating, "Please note on today's calendar that I received a phone call from Reince Priebus at 1:30 and one from President-elect Trump at 5 p.m. Thanks." 63. January 28, 2017 memo. Memo 2. The interaction between Comey and President Trump that resulted in Comey drafting a second memo. Memo 2 occurred on January 27, 2017. Comey told the OIG that President Trump called him at lunchtime on Friday, January 27, 2017, to invite Comey to the White House for dinner. Comey said that he assumed this would be a group dinner, similar to the Trump administration's January 22, 2017 group reception for law enforcement officials in the Blue Room of the White House, which Comey attended. Comey said he was not initially thinking in terms of memorializing any interaction between himself and the president on January 27, 2017. Comey told the OIG he was very surprised when he arrived at the White House that evening and discovered that he and the president would be dining alone. When we asked Comey whether the dinner invitation had been extended because of Comey's position as FBI director or because of a personal relationship with Trump, Comey told the OIG he did not have a personal relationship with President Trump and that if he had not been the FBI director, he would not have been invited to dinner by the president. Memo 2 states that Comey's dinner with President Trump lasted 1 hour and 20 minutes, during which they discussed a broad range of topics. Memo 2 states that, in writing the memo, Comey was attempting to recount in some detail only those parts that related in some way to his work. A portion of Memo 2 summarizes a discussion between Trump and Comey concerning the salacious material and Trump's wondering whether he should ask Comey to investigate the whole thing to prove it was a lie. According to Memo 2, Comey replied that the decision about whether to initiate an investigation was up to Trump, but that Comey said he wouldn't want to create a narrative that the FBI was investigating him, because the FBI was not, and Comey worried such a thing would be misconstrued. Another portion of Memo 2 states that Trump touched on Comey's future at various points, without any acknowledgement by Trump or Comey that we had already talked about this twice. Another portion of Memo 2 states that Trump touched on Comey's future at various points, without any acknowledgement by Trump or Comey that we had already talked about this twice. 61 According to Memo 2, at one point during the conversation, Trump stated that he needed loyalty and expected loyalty, and then later stated again, "I need loyalty." Single quote. Memo 2 reflects that the second time Trump stated his need for loyalty, Comey responded that the president would always get honesty from Comey. Memo 2 states that Trump then paused and said that's what he wants, honest loyalty, and Comey replied, "You will get that from me." Single quote. Memo 2 also notes that it was possible that Comey and Trump understood that phrase differently, but that Comey decided it would not be productive to push the subject further. Comey told the OIG that it was this utterly unexpected one-on-one dinner that started him into the practice of drafting memos to document his one-on-one interactions with President Trump. Comey said that, after dinner ended at about 8:00 p.m., he went home, opened his personal laptop, and started typing Memo 2. Comey told the OIG that he finished drafting Memo 2 before going to bed that evening, but went back in the morning and looked at it. And he was sure there were minor corrections that he made based on a night's sleep because he dated it January 28, 2017. Comey placed no classification, dissemination controls, or other handling markings on Memo 2, and told the OIG that in drafting Memo 2, he intended to write an unclassified summary of the encounter with President Trump. Comey said that, after reviewing Memo 2 on his personal laptop on January 28, 2017, he used his personal printer to generate 2 paper copies of Memo 2, which he referred to as 2 originals, placed handwritten page numbers in the upper right-hand corner of each page, initialed the last page of each original, added a handwritten date, January 28, 2017, and then deleted the electronic file from his personal laptop. Comey explained to the OIG that he is a maniac about hacking of his personal devices, and that he is obsessive about deleting files from his personal accounts. He told us that he never keeps any emails, personal emails, and tries to maintain almost a maniacal hygiene about records. When asked why, in light of these concerns, he did not write this memo on the FBI in classified or classified computers available in the Sensitive Compartmented Information Facility (SCIF) the FBI had installed in Comey's home. 62 Comey stated that I wasn't thinking about it belonging to the government. He thought, this is for me, so he used his personal unclass system. Comey told us that he put one original in his personal safe at home, where he stored personal, family-related things that mean the most to him. Comey acknowledged that, in theory, his wife also had access to this safe, but told us that at the time, she did not have a key and did not know where he kept his key. Comey told us he took the other original to FBI headquarters the following Monday morning, and gave it to Ribitsky, with instructions for Ribitsky to show Memo 2 to McCabe and Baker, then retrieve it and keep it at FBI headquarters in Ribitsky's possession. Comey told the OIG that he gave the second original to Ribitsky because Comey thought the memo might be necessary, at some point, to protect myself and to protect the FBI. Comey explained that because he was also thinking about the FBI, he made sure a copy was kept by Jim Ribitsky. Comey told the OIG that he drafted Memo 2 in a different style than Memo 1 because he thought about it differently. Comey said that, in his mind, Memo 2 was for me. Also for the FBI. But honestly, at this point I was thinking first about me, close second the FBI. He told us that he viewed Memo 2 as a personal aid memoir. And that's why I did it like this. On my personal device, non-FBI systems, and that I kept one of the originals in my safe, my personal safe, not the Bureau's. I had a Bureau safe. But I didn't put it in the Bureau safe because I didn't think of it that way. Comey told the OIG he created Memo 2 because he viewed Trump as fundamentally dishonest and was worried very much that Trump would say I had said things at this dinner that were not true, that I had promised him something, that I had given him assurances about something. Comey said he saw that possibility as dangerous to me, but also to the FBI. Comey told the OIG that during the dinner, the president asked for his loyalty, and that in that moment, Trump was not asking me for my loyalty because I'm a government employee. He wanted my loyalty, personally. And if President Trump were sitting here, I think he would consider that a personal conversation, I want you lashed to me. When pressed on why he viewed the dinner at the White House as a personal interaction, as opposed to an official interaction, Comey characterized it as a mix because he was director of the FBI, and a human being, and he felt that he needed to protect himself and the FBI by being able to remember what Trump said to me, what I said to him, for both of those purposes. Comey also acknowledged that it was hard to separate himself from the FBI because the personal assurances that Trump sought from Comey were linked to the power Comey held as FBI director. 4. February 8, 2017 Memo 3. On February 8, 2017, Comey authored a third memo, Memo 3, which summarized Comey's interactions at the West Wing earlier that afternoon with Priebus, then National Security Advisor Michael Flynn, and President Trump. Comey told the OIG he went to the White House on that day because Priebus had invited him. According to Memo 3, Priebus said that the meeting was a chance to get acquainted. Memo 3 states that, at one point, Priebus asked Comey whether their conversation was private, and then Priebus asked a question about FISA that Priebus said Comey could decide whether it was appropriate to answer. Memo 3 states that Comey paused for a few seconds and then said that he would answer here, but that this illustrated the kind of question that had to be asked and answered through established channels. According to Memo 3, Comey went on to explain that the normal channel was from DOJ leadership to the WH Counsel, and that it was important that communications about any particular case go through that channel to protect the FBI, and to protect the WH from any accusations of improper influence. And that Priebus responded by saying he understood. Memo 3 states that, after meeting with Priebus took Comey to the Oval Office to greet the president on Comey's way out, and described Comey's ensuing conversation with the president, which included a variety of topics. Comey told the OIG that he could not remember for sure, but thought he drafted Memo 3 shortly after the February 8, 2017 meeting. Comey told the OIG he could not remember which of his two classified systems he used to draft Memo 3, but said Memo 3 was definitely not drafted on any of Comey's personal devices. Comey told the OIG that at the time that he wrote Memo 3, he considered it to be a classified memo because it contained some discussion about FISA orders. However, Comey placed no classification, dissemination controls, or other handling markings on Memo 3 when he wrote it, and told the OIG he could not remember why he did not mark any portion of Memo 3 as classified when he created it. Comey also said he did not ask anyone else at the FBI to review Memo 3 for classification once he finished writing it. Comey told the OIG that, after he finished Memo 3, he printed 2 originals from an FBI printer, initialed each one, kept one original in his desk at the FBI and gave the other original to Ribitsky with instructions to show it to McCabe and Baker, then retrieve it and keep it. Comey told the OIG that, other than providing the original to Ribitsky to show to McCabe and Baker, he did not give a copy of Memo 3 to anyone else. Comey also said that, because he considered Memo 3 to be classified, he did not store it at home, but stored it in his desk at FBI headquarters. Comey told the OIG that the desk drawer where he kept Memo 3 had no lock, but that his whole office at FBI headquarters was a CIF that was alarmed, locked, and approved for open storage, so he never had to put away classified information. 5. February 14, 2017 Memo 4. On February 14, 2017, Comey drafted a two-page Memo 4, regarding his interactions in the Oval Office that day during a multi-person briefing and a subsequent one-on-one meeting with President Trump. These meetings occurred one day after Michael Flynn resigned as President Trump's national security advisor. Comey told the OIG that he was at the White House on February 14 for a Homeland Threat briefing, and that he had no expectation that he would be meeting alone with the president and having a one-on-one conversation. Memo 4 summarizes Comey's recollection of the individuals who attended the Homeland Threat briefing, how the president dismissed those individuals after the briefing concluded, including then Attorney General Jeff Sessions, which left Comey alone with the president, and the subsequent conversation that transpired. According to Memo 4, once Comey and Trump were alone, Trump said that he wanted to talk about Mike Flynn, and that Flynn hadn't done anything wrong in his call with the Russians. 63 Memo 4 further states that Trump said he had to let Flynn go because he misled the vice president. The president, according to Memo 4, then asked Comey about leaks of intelligence and other sensitive information, and Trump went on to state that the leaks concerning Flynn's communications with the Russian ambassador were terrible. Memo 4 states that Comey responded in part by stating, "If people run around telling the press what we do, the FBI's intelligence gathering ability will be compromised." After the discussion of leaks, Memo 4 states that Trump returned to the topic of Mike Flynn. According to Memo 4, Trump stated, "Flynn misled the vice president but he didn't do anything wrong in the call." Memo 4 further states that the president then said he hoped Comey could see his way clear to letting this go, to letting Flynn go. Trump continued, "Flynn is a good guy. I hope you can let this go." Memo 4 states that Comey replied by saying, "I agree he is a good guy," but said no more. In his June 8, 2017 written statement to the Senate Select Committee on Intelligence (SSCI), Comey said that he understood the president to be requesting that we drop any investigation of Flynn in connection with false statements about his conversations with the Russian ambassador in December. "I did not understand the president to be talking about the broader investigation into Russia or possible links to his campaign." Comey told the OIG that, after the meeting with Trump, he went home and drafted Memo 4 on his personal laptop, in a way that was very similar to Memo 2 from the post-January 27 dinner. Comey said that, after he finished drafting Memo 4, he printed two originals on his personal printer, initialed both, then put one in his personal safe and took the other to his office and gave it to Ribitsky with instructions to show it to McCabe and Baker, and then keep the original. Comey placed no classification, dissemination controls, or other handling markings on Memo 4. However, on the last line of the first page of Memo 4, Comey typed into the text, "Note, because this is an unclassified document, I will be limited in how I describe what I said next." Closing square bracket quote. Comey told the OIG he included this note because he knew that there might come a day when he needed Memo 4 to protect himself and/or the FBI. And it would be easier to accomplish that goal if it was unclassified. And so if he wrote it and included information that would have triggered classification, he couldn't keep it at home. And he was keen to make sure that he could keep this recollection recorded at home. He said he wrote Memo 4 in this way so that it would be clear that he was intentionally leaving something out if he was later questioned about the contents of the document. In his June 8, 2017 written statement to SSCI, Comey said he discussed with the leadership team at the FBI his February 14, 2017 interaction with the president. Comey said that he and the FBI leadership team decided not to report this conversation to the Attorney General or the Deputy Attorney General. Their reasoning was that Attorney General Sessions would likely recuse himself from involvement in Russia-related investigations. He did so 2 weeks later. The Deputy Attorney General's role was then filled in an acting capacity by a United States attorney, who would also not be long in the role. After discussing the matter, we decided to keep it very closely held, resolving to figure out what to do with it down the road as our investigation progressed. According to Comey's June 8, 2017 written statement, shortly after February 14, 2017, Comey spoke with Attorney General Sessions and took the opportunity to implore the Attorney General to prevent any future direct communication between the President and me. I told the AG that what had just happened, him being asked to leave while the FBI director, who reports to the AG, remained behind, was inappropriate and should never happen. 6. March 1, 2017 Memo 5. On March 1, 2017, Comey drafted a 4-line email, Memo 5, to Rybitsky memorializing a telephone call he had with President Trump that day. Comey told the OIG that Trump called him as Comey was about to get on a helicopter to travel to an event in Richmond, Virginia with his former Chief of Staff Chuck Rosenberg, who was serving as the acting administrator of the Drug Enforcement Administration at that time. Comey said he did not know in advance that the president would be calling him that day. According to Comey, it was a very short conversation that happened while Comey was still in the car at the helipad. Comey said he didn't consider it substantive. Comey told the OIG that he drafted Memo 5 on his unclassified FBI mobile device either from the car or at some point during the helicopter trip, and that it was just a few sentences, advising Rybitsky that there was not any interaction he needed to follow up on. Comey did not place any classification, dissemination controls, or other handling markings on Memo 5, and send Memo 5 to Rybitsky via the FBI's unclassified email system. According to Rybitsky's emails for March 2, 2017, Rybitsky contacted the Attorney General's Chief of Staff to relay the substance of the March 1, 2017 telephone call between Comey and Trump, and then emailed Comey to report that the Attorney General's Chief of Staff had expressed his appreciation for the readout. 7. March 9, 2017 telephone call, no memo. On March 9, 2017, Comey had a secure one-on-one telephone call with President Trump. Comey told the OIG that the secure telephone call was only business, and that there was nothing untoward about the call, other than it was unusual for the president to call the director directly. Comey said he did not prepare a memo to document this call with the president, but said he had Rybitsky arrange a secure call to Attorney General Sessions immediately afterwards to inform the Attorney General about the telephone call from the president in an effort to keep the Attorney General in the chain of command between Comey and the president. 8. March 30, 2017 Memo 6. On March 30, 2017, Comey wrote a 2-page memo, Memo 6, describing a 10-minute telephone call with President Trump at 8:13 a.m. Comey said that there was no lead-up to this telephone call. Comey told the OIG that he was having a conversation with Rybitsky prior to a morning staff meeting when the phone rang, and it was the White House switchboard, and they connected the president. Comey said that Rybitsky stayed sitting there throughout the call, but only heard Comey's end of the conversation. According to Memo 6, early in the conversation, Trump said that he was trying to run the country and the cloud of this Russia business was making that difficult. Memo 6 states that Trump asked what he could do to lift the cloud, and that Comey explained the FBI was working as quickly as possible on the investigation. Memo 6 also states that Comey told Trump that we weren't investigating him and that Comey had told the congressional leadership the same thing, and that Trump asked Comey several times to find a way to get that out. Memo 6 ends by noting that at 10:05 a.m., Comey called the acting Attorney General, Dana Boente, and relayed the substance of the conversation, so he could decide what guidance to give Comey, if any. 64 Comey told the OIG that he drafted Memo 6 on his unclassified FBI system. Comey said he intended to write Memo 6 in an unclassified way, the same as he would have done if he was home. Comey placed no classification, dissemination controls, or other handling markings on Memo 6. Comey told us that when he finished typing Memo 6, he printed 2 originals, dated and initialed them, and gave one to Rybitsky. He said it was highly likely, he told Rybitsky, to do what you've done before: show it to Baker, show it to McCabe, retrieve it, hold on to it. Comey said he thought of Memo 6 as a personal record, and thus took the second original home and stored it in his personal safe. Comey said that he likely deleted the electronic copy from the FBI's unclassified system, although he acknowledged it was possible that the electronic copy was still on the FBI's unclassified system. Comey said that by printing 2 hard copies, then storing one with Rybitsky at the FBI and the other in his personal safe at home, he was trying to accomplish 2 goals, which were protect myself, and protect the FBI. 9. April 11, 2017 Memo. Memo 7. On April 11, 2017, Comey authored a 1-page memo, Memo 7, containing a 2-paragraph description of a telephone call with President Trump. Comey told the OIG that he had no advance notice of this telephone call. Instead, Comey said that, on that day, he was in a meeting when his administrative assistant told him, "The president wants you to call him. And so I called him." Memo 7 states that Comey returned the president's telephone call at 8:26 a.m. and that they spoke for approximately 4 minutes. According to Memo 7, Trump said that he was following up to see if Comey did what Trump had asked last time, getting out that Trump is not personally under investigation. Memo 7 states that Comey responded by saying that he had passed the request to the acting AG and had not heard back. In response, Trump explained that any cloud, even a little cloud, interferes with the work he is trying to do for the country, according to Memo 7. Memo 7 states that Comey then told Trump how that type of request should be made by the White House counsel to Dana Boente, who was at the time serving both as the acting Deputy Attorney General and the acting Attorney General for the Russia investigation in light of Attorney General Sessions' recusal. Comey told the OIG that, similar to Memo 6, when the telephone call was finished, he typed Memo 7 on his unclassified FBI system at the desk in his office. Comey told the OIG that, at the time he wrote Memo 7, he didn't consider it to contain classified information. He said that, once Memo 7 was finished, he printed 2 originals, deleted the electronic file from the FBI system, gave one original to Rybitsky, and took the other original home to store in his personal safe. Comey placed no classification, dissemination controls, or other handling markings on Memo 7. Comey told the OIG that Memo 7 was the last memo he wrote about any interactions with President Trump. Comey also wrote in Memo 7 that he was still awaiting the guidance from acting AG Boente that he had sought on March 30, 2017, as reflected in Memo 6. An email communication from Rybitsky to Comey dated April 11, 2017, states that Rybitsky notified the AG of Comey's call with POTUS this morning, including the detail that the WH Counsel may reach out to DOJ today. 10. Handling, storage, distribution, and discussion of the memos while Comey was FBI director as described above, with the exception of Memo 1 and Memo 5, which Comey sent as emails. After drafting the memos, Comey printed and delivered an original of each memo to Rybitsky to keep at the FBI. Comey told the OIG he considered Memos 2, 3, 4, 5, 6, and 7 to be personal documents, rather than official records of the FBI. However, because Comey considered Memo 3 to be a classified memo, Comey said he never took a copy of Memo 3 home. Comey said he kept his copy of Memo 3 in his desk at FBI headquarters because he knew he did not have a legal way of maintaining and preserving classified information in his personal safe at home. And he said he was trying to be very careful about his obligation to safeguard classified information. Comey told us that while he was the FBI director, he did not have a conversation with anyone in the FBI about his view that the memos were personal documents. Comey also told the OIG that he did not remember discussing classification of the memos with anyone at the FBI. He said that it never occurred to him to put the memos through a classification review to confirm his belief that they contained no classified information. As part of this investigation, we interviewed multiple senior FBI officials, including Rybitsky, Baker, and McCabe, to determine who had access to the memos, and how they were handled by FBI personnel. McCabe told the OIG that he believed Comey was trying to limit knowledge about Comey's communications with Trump to a very, very small group of close advisors. McCabe said he thought Comey didn't want these memos floating around and widely distributed. McCabe's special counsel Lisa Page told the OIG that she thought Comey's objective in keeping the number of people exposed to the memos incredibly small was an effort to insulate the court team, who was doing the Russian investigation, from knowing any of this, so that it didn't, ultimately, impact their investigative steps. Baker said that Comey told him his concern at the time was the president's perceived effort to influence the investigation, filtering down to the people actually working on the case and impacting the ongoing investigation, and therefore only a very small group was informed about the interactions. Rybitsky told the OIG that, when Comey finished each memo, he gave Rybitsky an original of each, which Comey initialed in blue ink, so that Rybitsky could maintain originals of the memos at the FBI. According to Rybitsky, he kept the originals in a locked drawer in his desk, for which he had the only key, even though his office was approved for open storage of classified information. Rybitsky told the OIG that Comey said he also made a copy of each memo, which Comey marked copy. Rybitsky said Comey, in each instance, either gave the copy to McCabe, or gave the copy to Rybitsky to give to McCabe. Rybitsky told the OIG he also thought Comey showed some of the memos to Baker. Rybitsky also said he did not know at the time that the copy instructions were for those folks to read it and give it back to the director. Rybitsky said he did not know if Comey maintained these copies or destroyed them after McCabe and Baker had seen them, and did not know that Comey was keeping copies of some of the memos in his personal safe at home. Rybitsky also said he was not aware, at that time, whether McCabe or Baker kept any copies of the memos. Rybitsky said Comey authorized him to show the Deputy Chief of Staff at least some of the memos, but that, to Rybitsky's knowledge, she did not maintain separate copies. Baker told the OIG that with respect to Comey's interactions with Trump, Baker would have an oral conversation with Comey about what had happened, and Comey would say something along the lines of, "Rybitsky has the memo. If you want to look at it, go get a copy from him." Baker said that sometimes Rybitsky would give him a copy of a memo, and sometimes Rybitsky would give him the original, which Baker would read and give back to Rybitsky. According to Baker, prior to Comey's removal as director, Rybitsky had a complete set and Baker had a copy of some of them, which Baker said he kept in his office safe. Baker said if he wanted to review one of the memos he would take it out of his safe and read it in his SCIF. He told the OIG that, at the time, it was his understanding that the small group of people who had access to the memos really didn't want anyone to know the director was recording at this level of detail his interactions with the president, because any perception that Comey was keeping book on the president would upset any effort to have an effective and ongoing working relationship. According to Baker, one of the reasons no one conducted a contemporaneous classification review of the memos was that, as a practical matter, only 4 or 5 people actually knew about them before Comey was removed. Baker said he did not worry about the classification of the memos because he believed they were not going to go out the door of the FBI. Baker also said that, at that time, he presumed Comey was keeping copies of the memos in his office somewhere, and did not know that Comey was storing any copies of the memos at his home. Baker told the OIG he just assumed the memos were government records, because they're related to official business. Baker told the OIG that he remembered having a series of conversations with Comey concerning how to handle the one-on-one interactions with the president, during which Comey and Baker discussed what Comey should be saying, what he shouldn't be saying, should he be having these interactions, should he not, what should the role be of the department with respect to interactions with the president, and what should the director insist upon, with respect to interactions with the president. In other words, should Comey insist that these conversations go through the department? Should he insist that the DAG and the AG be aware of them? Or should he quickly notify the DAG and the AG about what was going on and the substance of these conversations? Baker said that eventually he urged Comey to tell the president that, if the president believed he needed information or wanted to communicate something to the FBI about a pending matter, such a communication had to go through the Attorney General or the Deputy Attorney General. Baker thought that Comey communicated this to Trump toward the end of these interactions. McCabe told the OIG that he remembered seeing all but one of the memos at the time they were written. 65 He said Comey showed him copies of the memos, and they discussed them. McCabe told the OIG he thought Comey was also sharing the memos with Ribitsky and Baker. McCabe said his practice was to read each memo, then give it back to Comey or shred it because it wasn't necessary for him to retain a copy. His understanding at that time was that Comey was going to preserve a copy, and that Comey's chief of staff was going to preserve a copy. McCabe told the OIG he assumed that Comey was keeping his copies at the FBI, and never discussed with Comey whether he had a set at home. McCabe forwarded Memo 1 to Page. Page told the OIG that Comey had met with a team conducting the Russia investigation after his January 6, 2017 meeting with Trump, and both told us of the substance, and also forwarded Memo 1 to members of the team to upload into the case file, because it was central to investigative activity. Page told the OIG that McCabe also allowed her to look at Memos 2, 3, and 4, but asked her not to share them with anybody. Page said that, on her own, she decided to make and keep copies of these memos because they were just of the nature that she felt like there should be one other copy somewhere else. She told the OIG that she did not know if others in the FBI were keeping copies of the memos. Page told us that she kept her copies of these memos in her office, which was a SCIF, inside her safe. FBI Assistant Director for the Counterintelligence Division E.W. Priestap told us that Comey orally described some of his conversations with Trump without showing Priestap copies of the memos. Priestap told the OIG that it was his impression that Comey briefed him on these conversations because these were extremely important topics that could impact the work of the FBI. Priestap said he believed Comey was telling him about these interactions with President Trump not because Comey was loose-lipped and wants Priestap to find this interesting. He's communicating with Priestap because of our responsibility in looking at all of the things we're looking at in an open investigation. In addition, while he was FBI director, Comey allowed his former chief of staff Chuck Rosenberg to review Memo 2, which described Comey's dinner at the White House with President Trump. At that time, Rosenberg was serving as acting administrator of the Drug Enforcement Administration and held an active TSA security clearance, but had no official need to know about Comey's interactions with President Trump. Rosenberg told the OIG he did not know whether the version of Memo 2 he reviewed was a draft or the final version. He said that he was at Comey's house during the weekend after the January 27, 2017 White House dinner. According to Rosenberg, Comey handed him a laptop. Rosenberg read the memo on the laptop screen, and then handed the laptop back to Comey. Comey told the OIG that it was possible he allowed Rosenberg to review Memo 2, but stated that he did not remember sharing it with him. However, Comey told the OIG that he remembered telling Rosenberg about the telephone call with President Trump on March 1, 2017, which was memorialized in Memo 5. Comey said that during the telephone call with Trump, Rosenberg was waiting for Comey in a helicopter to travel to Richmond, Virginia. Comey said he told Richmond about the January 27, 2017 dinner with Trump at the White House when Comey and Richmond met for lunch in late January or early February 2017. Comey told the OIG that Richmond was a close friend of his who had been on site at the FBI a lot because Richmond worked as a special government employee (SGE) until February 2017. 66 Comey said he did not show Richmond the January 28, 2017 memo at that time, but just described to Richmond the crazy story about the president wanting Comey's loyalty. Benjamin Wittes, the editor-in-chief of the Lawfare blog, wrote an article on May 18, 2017, describing what Comey had told him about Comey's interactions with President Trump. 67 In the article, Wittes described a lunch he had with Comey on March 27, 2017, during which Comey told Wittes about the hug Comey received from Trump during the January 22, 2017 reception for law enforcement officials in the Blue Room of the White House, the March 1, 2017 telephone call Comey received from Trump prior to boarding the helicopter, and a more general comment that Trump had asked for loyalty, and that Comey had promised him only honesty. Wittes' article stated that Comey never told Wittes the details of the dinner meeting, and that Wittes only learned that there had been a dinner meeting later, from published media reports. Comey told the OIG that he remembered having lunch with Ben Wittes in March, and told him the Blue Room story, because it was an amusing story. However, Comey told the OIG he did not think he told Wittes about the dinner with Trump at the White House. See Comey's March 20, 2017 congressional testimony on FBI's Russia investigation. On March 20, 2017, Comey testified before the House Permanent Select Committee on Intelligence (HPSCI) at a hearing titled The Russian Active Measures Investigation. During the hearing, Comey acknowledged that the FBI had an open investigation involving Russian interference in the 2016 election, but refused on at least a dozen occasions to answer questions about the scope of the investigation or to specify who was under investigation. For example, in his opening statement, Comey said the following: "I have been authorized by the Department of Justice to confirm that the FBI, as part of our counterintelligence mission, is investigating the Russian government's efforts to interfere in the 2016 presidential election, and that includes investigating the nature of any links between individuals associated with the Trump campaign and the Russian government, and whether there was any coordination between the campaign and Russia's efforts. Because it is an open ongoing investigation and is classified, I cannot say more about what we are doing and whose conduct we are examining. I know that is extremely frustrating to some folks. I hope you and the American people can understand. The FBI is very careful in how we handle information about our cases and about the people we are investigating. Our ability to share details with the Congress and the American people is limited when those investigations are still open, which I hope makes sense. We need to protect people's privacy. We just cannot do our work well or fairly if we start talking about it while we're doing it." When questioned by a member of Congress as to whether the FBI was investigating Flynn's conduct, Comey acknowledged the public's intense interest in the FBI's work, but noted, "We can't do it well or fairly to the people we investigate if we talk about it, so I can't comment." At another point in the hearing, when Comey was asked by another member of Congress whether FBI investigations sometimes conclude without a finding of wrongdoing, Comey replied, "That's one of the reasons we don't talk about it, so we don't smear people who don't end up charged with anything." The May 9, 2017 removal of Comey as FBI director. On Tuesday, May 9, 2017, at 5:03 p.m. President Trump removed Comey as director of the FBI. Comey was visiting the FBI's Los Angeles division when he was removed. He returned to Washington, D.C. on the FBI aircraft that night, and at approximately 2:00 a.m. on May 10, 2017, Comey's protective detail drove him to his home. Comey reported to Ribitsky that he locked his FBI devices and materials into his SCIF at home around noon on May 10, 2017, and took nothing out of the SCIF. FBI witnesses told the OIG that, as part of Comey's removal, President Trump directed that Comey not be allowed back into FBI headquarters. The FBI complied with that directive and, according to Ribitsky, made sure the director's office was locked down the evening of May 9, 2017. Comey told the OIG that, when he was removed as FBI director, he had 4 memos, Memo 2, Memo 4, Memo 6, and Memo 7, in his personal safe at home. He stated that he did not notify anyone at the FBI that he had retained these documents. He told the OIG that he had had them there for quite a while, and that because he viewed them as personal documents, like his will or his passport, it never would have occurred to him to give those back to the FBI. He also stated that he did not seek permission of the FBI to retain these memos, because he did not consider them to be FBI records. Comey told the OIG that the day after his removal, or very shortly thereafter, he retained attorneys Patrick Fitzgerald, David Kelly, and Daniel Richmond to provide advice and counsel in connection with Comey's termination as FBI director and any post-termination legal issues that might arise. FBI efforts to secure information and devices from Comey's office and home. On May 10, 2017, the morning after Comey was removed, a supervisory special agent (SSA) was appointed to secure and inventory Comey's office. The SSA told the OIG that he confirmed the office had not been accessed by Comey or anyone else after Comey's removal, and thereafter he positioned himself so that no one from the inventory team could leave the office with any items that didn't come past him. The SSA told the OIG that every item that came out of that office went on an inventory sheet. At the time that the SSA conducted the inventory, he was not aware that Comey had drafted the memos. According to the inventory, no hard copies of any of the memos were found in Comey's office. During a portion of the inventory, the FBI Assistant Director for the Office of Integrity and Compliance provided guidance to the inventory team about which items were government property and which items were Comey's personal property. The types of personal items found in Comey's office included photographs, books, coffee mugs, and a hockey puck. The items designated director records, government property, were detailed on 12 pages of inventory sheets, sealed in 10 boxes, and delivered to the FBI's Records Management Division, (RMD). Items determined to be personal property were detailed on 24 pages of inventory sheets, sealed in 23 boxes, and placed in a separate secure storage area at FBI headquarters until they could be returned to Comey. Following removal of these items, the inventory team resecured Comey's office. On May 11, 2017, the SSA returned to Comey's office to inventory, remove, and secure the electronic equipment. On May 12, 2017, the SSA and two other SSAs went to Comey's residence to inventory and retrieve all FBI property from Comey's home SCIF. They were accompanied by Rybitsky and the then FBI Associate Deputy Director, David Bowditch, who went to another area of the house with Comey while the SSAs inventoried and removed the government property, including electronic devices and documents. No hard copy versions of the memos were found in Comey's home SCIF, and Comey did not tell the FBI that he had copies of memos 2, 4, 6, and 7 in his personal safe. FBI preservation of the memos. Rybitsky told the OIG that, on the morning of Wednesday, May 10, 2017, Page contacted him to request a full set of the memos. Rybitsky said he asked her if the request was coming from McCabe, and she said yes. 69 Rybitsky said that he was surprised when he learned that Page already had copies of some of the memos because he didn't think anybody maintained a copy other than him, and didn't know how she got them. Rybitsky told the OIG that in response to Page's request, he made 3 sets of copies, one for himself, one for Page to give to McCabe, and one for Baker. He said he distributed the copies, but kept one set of the copies and the originals in the locked drawer in his office desk. Rybitsky told the OIG that other than Memo 1, none of these originals or copies had any classification markings on them. Priestap told the OIG that he received copies of the memos from Page. Priestap's then Deputy Assistant Director for the Counterintelligence Division, Peter Strzok, told the OIG that Priestap instructed him to upload the memos into the FBI's Sentinel case management system, an instruction Strzok said he understood to be relayed from McCabe and Baker. Strzok told the OIG that he participated in getting the memos, reading them, scanning them, and making sure they were serialized into Sentinel, into our case file so that there's a record there. Strzok said he thought he did this a night or two after Comey was removed, but told the OIG that the memos he uploaded were the raw ones, without classification markings. Strzok also said that the set of memos he initially uploaded was missing one or more of the memos, and that he did not have a complete set until later. 70 Strzok told the OIG that he helped enter the memos into the FBI's document management system as part of an electronic communication that was marked secret. All of the FBI senior leaders interviewed by the OIG stated that the memos were official government records. For example, McCabe described the set of memos as a record of Comey's official engagement with the president that was created by Comey in his role as FBI director. McCabe told the OIG further that, after Comey's removal, the FBI took steps to ensure that the memos were preserved in FBI systems as FBI records. Baker told us that the memos were related to official business, and that they were discussed in the office in connection with Comey's official responsibilities. Rybicki told the OIG that, since Comey's removal, Rybicki had treated the memos as FBI records. Rybicki also said he could not remember Comey ever indicating to him that Comey viewed the memos as personal papers. Priestap characterized the memos as documents produced by the director in his capacity as director, their FBI work product. FBI personnel with paper copies of the memos told the OIG that they kept them locked in safes in their offices. May 11, 2017 article in the New York Times. On May 11, 2017, the New York Times published an article entitled, "In a Private Dinner, Trump Demanded Loyalty. Comey Demurred." The May 11 article described the January 27, 2017, one-on-one dinner between Comey and President Trump in the Green Room of the White House, which Comey had memorialized in Memo 2. The New York Times cited as its source two people who have heard Comey's account of the dinner, and reported that, during dinner, Trump asked Comey for a pledge of loyalty. The May 11 article stated that, according to the account of the conversation from Comey's associates, Comey told Trump that Comey would give him honesty, but Trump pressed Comey on whether it would be honest loyalty. The May 11 article then stated that, according to Comey's associates, Comey stated, "You will have that." The May 11 article also reported on other details of the dinner, including that Comey tried to explain his role as FBI director, and told Trump that the United States was best served by an independent FBI and Department of Justice. The May 11 article also reported that Comey described the details of his refusal to pledge loyalty to Mr. Trump to several people close to him on the condition that they not discuss it publicly while he was FBI director. But now that Comey has been fired, they felt free to discuss it on the condition of anonymity. In addition, the May 11 article referred to the January 6, 2017 briefing at Trump Tower, which was memorialized in Memo 1. The article's description of the Trump Tower briefing did not contain any classified information that is referenced in Memo 1. Richmond confirmed to the OIG that he was one of the sources for the May 11 article, although he said he was not the source of the information in the article about the Trump Tower briefing. 71 Richmond said he knew about Comey's January 27, 2017 dinner at the White House because Comey had told Richmond about it sometime in the winter of 2017 while discussing job challenges Comey was facing, and how hard his job was getting. Richmond told the OIG that he learned Comey had been fired when a reporter for the New York Times called Richmond's cell phone on the evening of May 9, 2017 to ask, "What the hell is going on?" Richmond said he and the reporter had been friends for some time, and the reporter was one of several journalists who frequently called Richmond to ask questions about various news stories in the federal criminal world. Richmond said he told the reporter what he remembered about Comey's dinner with President Trump, including the honest loyalty piece. Richmond also said that at that time, he had not seen a copy of Memo 2, and the information Richmond provided to the reporter did not involve reading from a memo. During his interview with the OIG, Richmond was asked to review the last page of Memo 2, which described the president's comments about returning telephone calls from leaders of foreign countries. The copy of Memo 2 shown to Richmond by the OIG was redacted so that the names of the countries, which the FBI determined to be classified, as discussed below in Section IV, were not identified. Richmond told the OIG that he had not disclosed any information to anyone from Memo 2 about the president's statements regarding returning telephone calls from foreign leaders or any specific country names. We showed Baker, McCabe, and Page the portion of the May 11, 2017 article that says the information came from two people who have heard Comey's account of the dinner, and asked them if they knew who those two people were. They each told us that they did not. Rybitsky similarly told the OIG that he did not provide the contents of any memos to anyone outside the FBI. When we asked Comey whether he knew who the two sources were for the article, he said that he was highly confident Richmond was one of them, but that, "I don't think I know who the other one is." Comey further stated that Richmond was not speaking to the New York Times at Comey's direction for the May 11 article. President's tweet on May 12, 2017. On May 12, 2017, President Trump released a tweet stating, "James Comey better hope that there are no tapes of our conversation before he starts leaking to the press." Comey told the OIG that he was aware of the tweet but didn't pay much attention to it because at that point in time he was trying to block it all out. Copies of the memos are provided to the OIG. Shortly after Comey's removal, a set of the 7 memos was provided to the OIG by a department employee who claimed whistleblower status. This individual viewed the memos as extremely sensitive documents and was concerned that there should be a separate set deposited somewhere for safekeeping. The OIG handled and stored all 7 memos consistent with the requirements for classified information, even though only Memo 1 had any classification markings at that time. Comey provides scanned copies of memos 2, 4, 6, and 7 to his attorneys via email. As described in this section, on May 14, 2017, Comey transmitted copies of memos 2, 4, and 6, and a partially redacted copy of memo 7 to Fitzgerald, who was one of Comey's personal attorneys. Comey told the OIG he thought of these memos as his recollection recorded, like a diary or personal notes. Comey also said he believed there's nothing classified in here, and so he thought he could share them with his personal attorneys. Comey told the OIG that, before sharing these memos with his attorneys, he redacted the second paragraph of Memo 7, which contained a discussion of foreign affairs during which Trump asked Comey to follow up on a specific matter. Comey told the OIG he redacted this paragraph because it was utterly unrelated to what I was seeking their advice and counsel about. He did not consider that paragraph classified, he just thought that it was irrelevant. Comey said that he used the personal scanner at his home to make a copy of Memo 7, then used a marker to black out 15 lines from the second paragraph of the copy of Memo 7. Comey also placed an index card on which he handwritten the word "redacted" over the center portion of the blacked-out paragraph, further obscuring most of the second paragraph of Memo 7. When Comey was finished redacting, the second paragraph read, he then switched topics, redacted, then said that I was doing a great job and wished me well. The call ended. A copy of the redacted version of Memo 7 Comey created as contained in Appendix B to this report. 72 Comey then used his personal scanner to create a portable document format PDF file containing 4 of the Comey memos, unredacted copies of Memos 2, 4, and 6. And the redacted copy of Memo 7.73 on May 14, 2017, Comey attached the PDF to an email from his personal email account, and sent the email and PDF attachment from his personal laptop to Fitzgerald's personal email account, with instructions for Fitzgerald to share the email and PDF attachment with Kelly and Richmond. Fitzgerald received the email and PDF attachment from Comey at 2:27 p.m. on May 14, 2017. Fitzgerald forwarded the email and attachments to Kelly on May 17, 2017, at 7:35 a.m. and to Richmond on May 17, 2017, at 10:13 a.m. Richmond told the OIG that, when he received the email and attachments from Fitzgerald, he accessed the files from his computer, read them, and downloaded a copy into a separate file on his computer. Richmond said he did not make any paper copies of the memos. Fitzgerald also forwarded the email and attachments from his personal email account on May 17, 2017, at 4:47 p.m. to another email account belonging to Fitzgerald. Fitzgerald then saved the PDF attachment onto his computer, after which he said he placed the incoming email from his personal email account into the deleted items folder. Comey told the OIG that he did not notify anyone at the FBI that he was going to share these memos with anyone, and did not seek authorization from the FBI prior to emailing these 4 memos to Fitzgerald. Comey told the OIG that he deleted his electronic versions of the email and the PDF attachment that he sent, and did not retain a hard copy of either. May 15, 2017, Comey's chief of staff informs SSA of existence of Comey memos. According to notes maintained by the SSA in charge of inventorying Comey's records, on May 15, 2017, Rybitsky notified the SSA that there were additional documents belonging to Comey stored in the reception area near the former director's office, in desk drawer safes belonging to Comey's administrative assistant, and in Rybitsky's office. These documents were collected into 2 boxes and, among other things, contained 6 of the original memos. The SSA's notes reflect that Rybitsky also told the SSA about a 7th document, Memo 5, that Comey had sent to Rybitsky on March 1 via the FBI's unclassified email system. And Rybitsky provided the SSA with a copy of the email. 74 The SSA told the OIG that this was the first time he learned about the existence of the memos. And Rybitsky provided the SSA with a copy of the email. 74 The SSA told the OIG that this was the first time he learned about the existence of the memos. According to the SSA's notes, Rybitsky told the SSA that he did not tell anyone about the memos during the May 10 inventory because he understood that process to only include Comey's office. The SSA inventoried the 2 additional boxes of documents, including the memos, and then transferred these 2 boxes to RMD's custody. Comey provides Richmond digital photographs of Memo 4 via text message on May 16, 2017. Comey told the OIG that on Tuesday, May 16, 2017, he woke up at 2 o'clock in the morning, like struck by a lightning bolt. He said he suddenly realized that if, as the president had said in his May 12, 2017 tweet, there were tapes, then Comey's version of his one-on-one conversations with Trump could be corroborated. In particular, Comey told us he thought that the president would be heard on that tape asking Comey to let Flynn go, as Comey had documented in Memo 4. Comey said he also realized that Trump will eventually figure out he shouldn't have said that, and he may well destroy the tapes, so somebody needed to preserve them. Comey said he was lying there, playing this in my mind. And I thought, you know what, I can actually do something. That if I put out into the public square that encounter, that will force DOJ, likely to appoint a special counsel to go get the tapes. Or even if they won't do that, it will force them to go get the tapes. Comey told the OIG he lay awake thinking the tapes could be preserved but only if I spur the appointment of a special counsel by putting this out. On the morning of May 16, Comey took digital photographs of both pages of Memo 4 with his personal cell phone. Comey then sent both photographs, via text message, to Richmond. 75 Comey told the OIG that he transmitted this copy of Memo 4 to Richmond on May 16 because Comey had a specific assignment for him. Comey told the OIG he knew Richmond had a close relationship with a reporter for the New York Times. According to Comey, he directed Richmond to share the content of this memo, but not the memo itself, with the reporter. Comey also said that, although Richmond was his attorney at the time, Comey didn't intend to assert any kind of privilege about the direction he gave to Richmond. Comey told the OIG he directed Richmond to share the contents of Memo 4 with the New York Times because I had a conversation with the President of the United States. It was unclassified, on February the 14th. I'm a private citizen. I can talk about conversations I had with the President of the United States. I happen to have that conversation enshrined in an accurate way in this memo. So to ensure that the newspaper gets the most accurate account of my recollection, I'll send the memo to Richmond. Tell him, use this, don't give them the memo, but use this to communicate the substance of it. Comey told us he needed to do this because it was something he was uniquely situated to do, because he was now a private citizen. He told us that by speaking out, or enabling someone else to speak out, it would change the game, and create extraordinary pressure on the leadership of the Department of Justice, which Comey did not trust, to appoint someone who the country can trust, to go and get those tapes. When asked whether he considered that his disclosure of this information would significantly affect FBI equities, he told the OIG that he would frame it differently, as an issue of incredible importance to the nation as a whole. Comey said he took the actions he took because he was doing something I had to do if I love this country, and I love the Department of Justice, and I love the FBI. Comey told the OIG that notifying the FBI and Department of Justice about his plans before disclosing the contents of Memo 4 was not something he could do if I care about the country. Comey said that he did not want to put the leadership of the FBI in an impossible position by notifying them ahead of time, because if he asked them to approve what he was planning to do, they'd have to tell the leadership of the Department of Justice that the former director is contemplating doing this, and Comey believed it was better that he not engage them. 76 Accordingly, Comey stated that he did not notify anyone at the FBI that he was going to share the contents of the Memo 4 with Richmond or the media, and that he did not seek authorization from FBI to provide Memo 4 to Richmond. We asked Comey why he used Richmond rather than providing the information directly to the media. Comey told the OIG that, at that time, there was an army of reporters and cameras at the end of his driveway. He said he thought about talking directly to them, but decided that would be crazy, like feeding seagulls at the beach, and would create an expectation that I will then be their media rep. Comey said he did not want to be interviewed or answer any follow-up questions. He told the OIG that, at the time, he thought that the smartest thing for him was just to get the information out in a way that he did not have to answer questions, to avoid creating even more of a storm than was already going on. Richmond told the OIG that he received a text from Comey containing a memo, whose substance he very quickly thereafter passed on to the reporter. Richmond said that the memo he received from Comey did not have any classification markings or designations connected with it, it was not on government stationery, and in Richmond's view, had all the markings of a personal memo. Richmond also told the OIG that he knew the memo did not contain classified information because he understood that Comey was an original classifying authority, and knew that Comey would not put Richmond in a difficult position. Richmond received the text on his personal cell phone, and told the OIG that he thought the text originated from Comey's personal cell phone. Richmond told the OIG he did not give a copy of the memo to the reporter. Instead, Richmond relayed to the reporter the contents of the memo in a telephone call. Richmond said he conveyed the contents of the memo to the reporter because Comey asked him to, and Richmond felt that he was helping a client get information out that was unclassified, unprivileged, that the client wanted to get out, that was of enormous national importance. And Richmond thought this was precisely the right thing to do. When asked whether he was acting as Comey's attorney or as Comey's friend by contacting the reporter, Richmond told the OIG that he would have to say it was both, and that while one could imagine situations where parsing of that sort was necessary, Richmond never found those occasions arose. Comey told the OIG that he did not share the photographs of Memo 4 with anyone else, and that after he texted the photographs to Richmond, he deleted the text and photographs from his personal cell phone. May 16, 2017 article in the New York Times. On May 16, 2017, the New York Times published an article entitled, Comey Memo Says Trump Asked Him to End Flynn Investigation. The May 16 article described a meeting in the Oval Office in February 2017 during which, according to a memo, Comey wrote shortly after the meeting, President Trump asked Director Comey to end the federal investigation into Trump's former national security advisor, Michael Flynn. The May 16 article described the meeting in detail, stating that Comey had been in the Oval Office that day with other senior national security officials, but that Trump told those present, including Vice President Pence and Attorney General Jeff Sessions, to leave the room. The May 16 article stated that, once the president and Comey were alone, the president told Comey that Flynn had done nothing wrong, and stated, "I hope you can see your way clear to letting this go, to letting Flynn go. He's a good guy. I hope you can let this go." The words attributed to President Trump as direct quotes in the May 16 article are the same words that appear in quotation marks, and are attributed to Trump as direct quotes, in the text of Memo 2. The sources for the May 16, 2017 article were described as a memo Comey wrote shortly after the meeting, and two people who read the memo. The May 16 article further stated that The New York Times has not viewed a copy of the memo, which is unclassified, but one of Comey's associates read parts of it to a Times reporter. The May 16 article also reported that two people had confirmed that Comey created similar memos, including some that are classified, about every phone call and meeting he had with the president. When asked who the two sources were, Comey said he did not know who the source was other than Richmond, but told the OIG it has to be somebody inside the FBI who saw the memos, and that the second individual did not share this information at Comey's request. "We asked Baker, McCabe, Ribitsky, and Page whether they knew the identity of the second source. Each told us that they were not the second source and did not know who the second source was." N. The FBI's June 2017 classification review of the memos following the publication of the May 16, 2017 article in the New York Times, the FBI received numerous congressional requests for copies of the memos, as well as congressional requests for testimony from the FBI concerning the memos and the Russia investigation. The FBI also received numerous requests for the memos under the Freedom of Information Act (FOIA). In the same general time frame, several congressional committees, including the Senate Select Committee on Intelligence (SSCI), asked Comey to testify. Comey told the OIG he agreed to testify before SSCI and notified the FBI that he would be testifying. The SSCI hearing was scheduled for June 8, 2017. Because the SSCI hearing would be an open session, the FBI needed to make a clear determination whether there was any classified information in the memos before Comey testified. In addition, Comey requested that the FBI allow him to review the full set of his memos prior to the hearing, so that he could prepare a written statement for submission to SSCI and refresh his recollection before testifying. Comey told the OIG that his purpose in requesting to review the memos was to make sure, as he drafted the statement and testified, that he didn't reveal any classified information. The FBI's classification review of the memos occurred in two stages. First, on June 1, 2017, Baker met with the unit chief of the FBI's Counterintelligence Law Unit in the FBI's Office of General Counsel, the unit chief Page, and Strzok to review the memos and make recommendations as to whether any of the information in the memos should be marked as classified. Thereafter, on June 6, 2017, the unit chief met with Priestap to brief him on the recommendations, so that Priestap could make the final determination on whether any of the memos contained classified information. The unit chief told the OIG that the final classification decision was brought to Priestap as the OCA who had jurisdiction over the subject matter of the memos, including the FBI's ongoing investigation into Russian interference in the 2016 presidential election. We discuss these stages of the FBI's classification review in detail below. 1. OGC review of the memos. The initial review of the memos to identify any potentially classified information was performed by Baker, the unit chief Page, and Strzok. Strzok characterized Baker, the unit chief Page, and himself as a logical subset to sit and go through the memos and review them for classification because these individuals had a lot of history and experience of working investigations relating to the disclosure of classified information, including the Chelsea Manning disclosures, the Edward Snowden matter, and the Clinton email investigation. Baker was one of the designated OCAs for the FBI. Baker also had substantial past experience working with the National Archives on disclosure of classified documents, and characterized that experience as having sensitized him to the State Department's concern that the release of candid assessments of foreign nations and their leaders might be problematic with respect to our diplomatic relations, which was one of the issues involved in the classification review for the memos. The unit chief told the OIG that her day-to-day responsibilities in the FBI's General Counsel's office included often reviewing the classification guide and helping the agents figure out what is classified, and said she had some experience assisting FBI OCAs in making formal classification decisions, but stated that she doesn't do that very often. Page told the OIG that she had been part of an extraordinary number of declassification reviews over the course of the last 5 years post-Snowden. Baker and the unit chief told the OIG that their classification review for the memos differed from the FBI's normal process, which usually involves sending documents out to the agency whose equities are at issue for their classification determination. One of the unit chief's subordinates, an assistant general counsel in the counterintelligence law branch who participated in the classification review for Memo 2, told the OIG that, given the urgency of how quick they were looking at doing the classification review, the memos were not referred for State Department input. Instead, where the equities at issue belong to the State Department, the FBI personnel involved in the classification review told us that they relied on their experiences in the Clinton email case and their familiarity with what the State Department classified in her emails, and used that to determine whether specific statements by the president about foreign leaders were classified. On June 1, 2017, Baker, Strzok, the unit chief, and Page met to conduct a line-by-line review of the memos. According to Baker, one of the overall issues these individuals discussed was whether it was appropriate to review Comey's decisions about whether the memos contained any classified information because Comey was an FBI OCA at the time that he wrote the memos. Baker told us that the decision to conduct the classification review was based on the fact that once Comey was gone, then the burden fell back onto other people to review this material and classify it or not. And so at that point in time, it was up to us to decide, not him, whether we think anything is classified because we're the ones who are going to hand it out. We're now the responsible parties. Page told the OIG that they all believed Comey had intended to write the memos in an unclassified way and that his intent was meaningful because he authored the documents. Page said, our objective was to protect the FBI and not the director. And so, it was our assessment as to whether the information was classified. Baker told the OIG he remembered Comey mentioning that he thought he had written the memos in an unclassified way. Strzok said his belief was that given this low level of this material, Comey simply didn't think it was classified. Strzok believed Comey simply thought this was all kind of unclassified FOUO type of stuff. The unit chief said she similarly thought Comey had not classified them. And he, himself, is an OCA. So he may not have known it was classified when he shared the memos. Page told the OIG that they approached the memos like a declassification review, and tried to be as transparent as possible, while still protecting sources, methods, and other matters which need to be properly classified. Page added that the group was probably more conservative than not, but that they tried to be fair and thoughtful as they went through the process. Baker similarly said that they were trying to make sure that we protect classified information, but on the other hand, we did not want to be accused of overclassifying. Baker added that they wanted to make sure that, whatever they recommended, pre-step would be able to swear under oath, sign an affidavit, whatever, establishing and defending the classification. Strzok said that, in reviewing the memos for classified information, they tried to make sure they were being rigorous and objective and by the book. And neither too strict nor too lenient. Just absolutely straight down the line on this. The unit chief told the OIG that, during the June 1, 2017 meeting, the participants had some back-and-forth discussions about what should be classified, and that there was definitely a debate over some of the issues. According to Baker, some of those discussions were lengthy, and that the group sometimes started down one path and then reversed the course later. So, it took a while to get through them. Strzok characterized the meeting as involving a lot of discussion about is this classified, and if so, why, and where that would fall in the classification guidelines. None of the participants kept notes of the meeting. Once the group reached agreement, Page placed handwritten brackets around the words in each of the memos that they thought contained classified information. As a result of their review, Baker, Strzok, the unit chief, and Page recommended classifying portions of Memo 2, Memo 3, and Memo 7, which had not been marked classified by Comey. At the time they conducted this review, none of these individuals knew that Comey had shared copies of Memos 2, 4, 6 and 7 with his attorneys. The portion of Memo 2 that the group recommended for classification involved a story Trump told Comey about Trump's then National Security Advisor, Michael Flynn, to illustrate that Trump had concerns about Flynn's judgment. As recounted by Trump, Flynn failed to immediately tell the president about a telephone call from a leader of a foreign country, and Flynn scheduled a return call 6 days later, which Trump viewed as an inappropriately long lag time in light of the country involved. According to Memo 2, in conveying how upset he was with Flynn, Trump made a comparison of 3 countries, one of which the memo notes Trump mentioned twice, reflecting Trump's personal views on the relative importance of promptly returning telephone calls from 2 of the countries, but not the third. In its unredacted form, Memo 2 specifically identifies the countries in Trump's comparison, and attributes to Trump a direct quote about one of the countries. Baker told the OIG that even if it's self-evident that, in this geopolitical sense, that some countries are more important than others, a comment by the president to that effect could be viewed as disparaging, and thus had the potential to harm the foreign relations of the United States. Strzok said that while, to the average observer, a lot of people would look at this and say, well, that's not classified, the consensus was that the president's remark would be considered classified by the State Department. The unit chief told the OIG she would not be shocked if someone else had a different opinion as to whether this was classified information, but that this was their best guess in our attempts to protect as much as possible, so we didn't accidentally cause a foreign incident. Page told the OIG that the group thought it was appropriate to simply redact just the names of the countries from Memo 2, and that would protect the president's ability to speak about other countries and not have that be revealed. The recommendation to pre-step for Memo 2 was to classify 6 words from 3 sentences in that paragraph as confidential, NOFORN, because that was the level of classification assigned by the State Department to the same type of information in the Clinton email case. After the group agreed on the recommendation for Memo 2, the unit chief showed a copy of the proposed classifications to the Assistant General Counsel and asked for his opinion. The Assistant General Counsel had served as one of the FBI's liaisons for resolving classification issues with the State Department during the Clinton email investigation. The Assistant General Counsel said he agreed with classifying the president's references to the countries in Memo 2 because that was how he believed the State Department would classify these statements. The Assistant General Counsel told the OIG that the FBI's classification guide doesn't categorize this type of information in the same way, but that it is the FBI's practice to treat State Department information relating to foreign relations as classified until they can get a definitive ruling from the State Department. He said that the FBI did not seek the input of the State Department on the classification of the memos, given the urgency of how quick they were looking at doing the classification review. For Memo 3, Baker, Strzok, the unit chief, and Page recommended marking several sections as classified. In their interviews with the OIG, each of these individuals explained that portions of Memo 3 were considered classified because they provided the name of an individual involved in a defensive briefing, discussed information from ongoing investigations, addressed FISA coverage, or implicated foreign relations. In total, they recommended designating portions of 7 paragraphs of Memo 3 as secret, NOFORN. As described earlier, Comey considered Memo 3 to be classified when he drafted it, but did not apply any classification markings to it. With respect to Memo 7, Baker, Strzok, the unit chief, and Page evaluated the second paragraph of this two-paragraph memorandum, which contains the president's assessment of the leader of a foreign country and describes a foreign event that Comey was asked to follow up on by Trump. Baker told the OIG that, in discussing Memo 7, the group spent a lot of time discussing whether disclosure of the information could harm to the United States, the national security. The United States or the foreign relations of the United States, in a way that Priestap could defend. Baker told the OIG that, similar to Memo 2, the president's statements as recorded in Memo 7 had the potential to harm the diplomatic relations of the United States, the foreign relations of the United States, by disclosing the president's mental view of a foreign leader. Baker said that, instead of taking out all of the words that the president said, they tried to be circumspect with respect to what they were taking out and to be sort of efficient and elegant with respect to any redactions. Strzok, the unit chief, and Page likewise told the OIG that portions of Memo 7 were classified to protect the president's assessment of a foreign leader, and prevent any impact on foreign relations. Baker, Strzok, the unit chief, and Page ultimately recommended redacting 15 words identifying specific countries or leaders from Memo 7. This recommendation was based on their familiarity with the information the State Department classified in the Clinton email case, and their belief that a discussion about a foreign leader by the president would be classified at the confidential level by the State Department. 2. OCA classification of the memos. On June 6, 2017, the unit chief met with Priestap to review the bracketed portions of the memos and have Priestap determine appropriate classification levels for the information. Priestap told the OIG that he wanted to have the classification review done before former Director Comey testified, so that we'd know what's classified on there and what's not. Priestap told the OIG that the classification process was done very carefully. He said that his role in the process was to determine whether the memos contained classified information or not, but that by the time he made his determination, every line would have been carefully reviewed to highlight for me any potential concerns. In particular, Priestap said that he had often reviewed documents for classification with the unit chief, and that their process was to go through documents, and she'll point out where she might think it's classified. And I'll want to know the reasoning, so on and so forth. And then I can make a final determination. But I can get her, or other experts' input, before making that final determination. Priestap told the OIG that in this case, he followed that usual practice. The unit chief told the OIG that Priestap may have had a few questions, but he did not question the decisions about classification designations recommended to him. At Priestap's direction, the unit chief handwrote in the classification levels next to the brackets in the text and appended the following handwritten classification block to Memo 1, Memo 2, Memo 3. And Memo 7, classified by ADCD, derived from FBI NSICG, dated 20,130,301, to classify on 2,042,123,177 according to the unit chief and Page. Strzok added typewritten banner markings to the top and bottom of all 7 memos. Comey's preparation for and testimony to the Senate Select Committee on Intelligence. As described earlier, Comey agreed to testify before SSCI on June 8, 2017. On the day prior to that hearing, the FBI provided Comey with a set of 7 memos for him to review at home in preparation for the hearing, and Comey returned to the FBI the signed originals of memos 2, 4, 6, and 7 that he had kept in his personal safe at his home. We describe below the details of these events, as well as Comey's responses to questions from senators about his sharing of the memos with others. 1. Comey's June 7, 2017 review of the memos with the FBI's classification markings. On June 7, 2017, the FBI provided a set of 7 memos with banner and classification markings to Comey to review at his home, so that he could prepare for his congressional testimony. At that time, Comey still held a security clearance to review classified material. The SSA who hand-carried the memos to Comey said that Comey reviewed the set of 7 memos on the back porch at his house for approximately 20 to 30 minutes, but did not take notes. Comey pointed out to the SSA that the copy of Memo 6 provided by the FBI was incorrectly marked secret on the second page when it should have been marked classified. The SSA did not recall Comey indicating that any of the other markings were inaccurate. Comey told the OIG that this was the first time that he became aware that the memos had undergone a classification review, and that when he reviewed the memos that had been marked for classification, he remembered being struck by the terms they had decided were confidential. Comey told us that his reaction to the classification markings he was shown was, some seemed reasonable. Some seemed overly conservative, in his judgment. In particular, Comey took issue with the classification markings placed on Memo 2 because they made no sense to him at all, because he did not see how release of that information damages the security of the United States. Comey told the OIG he did not understand the president to be insulting one of the countries named in Memo 2, but instead to be saying it's simply a smaller country. He told us that his reaction was, "Are you guys kidding me?" But that he did not engage with the agents who brought the memos to him for review because those agents had no role in the classification determinations. Comey also told the OIG that the fact that he was an OCA at the time he wrote the memos was not necessarily determinative of whether the memos were classified. He said an OCA's role is to make an initial judgment, but that doesn't mean someone with equal good faith and equal experience, or maybe different optics from experience, might not make a different judgment. According to Comey, after-the-fact classification reviews happen all the time. Comey said that he does not begrudge the classification review for the memos, because it's a legitimate part of the process for someone to go through. Comey compared being an OCA to being an umpire, and said that as an OCA he had to make the best judgment he could in the moment, but that it is totally legitimate for people to dispute the call after that, or say, "He blew that one, that was wrong." Comey told the OIG that it's the agency who owns the information that gets to make the final judgment, and that he has no standing to make decisions about that sort of thing anymore. Comey said he understood that the obligation to protect the classified information in the memos existed even though he viewed the memos as personal recollections. 2. Comey returns his copies of the memos to the FBI. Also on June 7, 2017, Comey provided the SSA who came to his home with Comey's signed originals of Memos 2, 4, 6, and 7, which were the only memos that Comey said he had retained at his residence. The SSA said he had been advised ahead of time that Comey had memos to give to him. The SSA said he took the 4 memos from Comey and provided Comey with a property receipt. The SSA told the OIG he executed a personal property receipt for the memos because anytime he collects something from somebody, he does a property receipt, just to document the fact that he got it from that person. The SSA told the OIG that Comey did not indicate that he had shared these memos with anyone outside of the FBI, or that there might be an unauthorized disclosure of classified information. The SSA also said that Comey did not indicate that he considered the memos to be his personal property. When asked whether the FBI's classification markings raised any concerns for Comey about his storage and transmission of the memos, Comey stated, "Sure. Yeah. 2 things ran through my mind. Immediately it is like, could I be wrong? Which is something I'm always trying to ask myself, could my judgment have been wrong? And if they're classified, what are the implications for that, because I stored and transmitted?" Sure. Comey told the OIG that he understood that the FBI would likely conduct an investigation concerning the unauthorized disclosure of classified information, and he said he thought that's totally reasonable. However, Comey told the OIG that he voluntarily gave his signed originals of memos 2, 4, 6, and 7 to the SSA at his house that day, not because he had concerns that they contained classified information, but because special counsel Robert Mueller asked for them. When asked if he told the agents that he had shared the memos with his attorneys, Comey told the OIG he had no recollection of telling the agents at his home or anyone else in the FBI that he had shared memos 2, 4, 6, and 7 with Fitzgerald, Kelly, and Richmond. Comey also said that, at some point the FBI learned that he had provided these memos to his attorneys, but that Comey could not remember how the FBI learned that. As described below, the FBI first learned that Comey had shared Memo 4 with Richmond while watching Comey's public testimony before SSCI on June 8, 2017. Comey also never informed the FBI that he had shared memos 2, 4, 6, and 7 with Fitzgerald, Kelly, and Richmond. Rather, the FBI first learned this information from Richmond. 3. Comey's June 8, 2017 testimony. On June 8, 2017, Comey testified before SSCI. Comey answered a number of questions from senators concerning the creation, handling, and sharing of the memos, and provided the following information in response to questions from Senator Collins and Senator Blunt. Collins, and finally, did you show copies of your memos to anyone outside the Department of Justice? Comey, yes. Collins, and to whom did you show copies? Comey, I asked, the president tweeted on Friday, May 12, after I got fired, that I better hope there's not tapes. I woke up in the middle of the night on Monday night, because it didn't dawn on me originally that there might be corroboration for our conversation. There might be a tape. And my judgment was, I needed to get that out into the public square. And so I asked a friend of mine to share the content of the memo with a reporter. Didn't do it myself, for a variety of reasons. But I asked him to, because I thought that might prompt the appointment of a special counsel. And so I asked a friend of mine to do it. Collins, and was that Mr. Witz? Comey, no. Collins, who was that? Comey, a good friend of mine who's a professor at Columbia Law School. Collins, thank you. Blunt, but you said something earlier I don't want to fail to follow up on. You said, after you were dismissed, you gave information to a friend so that friend could get that information into the public media. Comey, correct. Blunt, what kind of information was that? What kind of information did you give to a friend? Comey, the Flynn conversation, that the president asked me to let the Flynn, I'm forgetting my exact own words, but the conversation in the Oval Office. Comey told the OIG that he did not tell Senator Collins about sharing 4 of the memos with his 3 attorneys because Comey was trying to answer the question that he was asked, and not reveal confidential communications with my lawyers. Comey said that, in his view, there is a distinction between communications to his lawyers for the purpose of obtaining legal advice, and communications to another person, who happens to be one of his lawyers, to accomplish a task for him, which was acting at his direction to release something to the media. Comey told the OIG that he referred to Richmond as his friend, rather than as his attorney in the SSCI testimony because Comey didn't consider what he asked Richmond to do privileged. And Comey didn't intend to assert any kind of privilege about the direction to Richmond. Comey also said that the reason he did not clarify that he had shared more than one memo with more than one person was that they, SSCI, didn't ask any follow-up questions. Comey told the OIG that, if they pressed and asked follow-up questions, he would have had to say something like, well, other than confidential communications with counsel, or something like that. FBI retrieval of memos from Comey's attorneys. All of the FBI witnesses told the OIG that the FBI first learned that Comey had shared at least one of the memos with someone outside the FBI during Comey's June 8, 2017 congressional testimony. Strzok told the OIG he was watching Comey's testimony with several people, including Baker and Rybitsky, and that when Comey stated he gave a memo to a friend, everybody in the room knew. Oh, that's Richmond. Baker told the OIG he remembered literally running down the hallway to his office with Strzok, finding Richmond's telephone number, and getting Richmond on the phone right away. Baker, who knew Richmond, said he introduced Strzok and then left the call to watch the remainder of Comey's SSCI testimony. Strzok told the OIG that he asked Richmond to please preserve anything that Comey had given him. Strzok told the OIG that either during this call or a subsequent one, he told Richmond that what he received might contain classified information. Strzok said that sometime after the initial call with Richmond, he learned that David Kelly and Patrick Fitzgerald might also have copies of some of the memos. Strzok's handwritten notes of his conversations with Richmond established that by no later than June 9, 2017, Strzok knew that all three of Comey's attorneys had electronic copies of 4 memos. Richmond told the OIG that he remembered the initial telephone call with Baker and Strzok but did not have an extensive recollection of what was said. He said the conversation went along the lines of, "Would you give us the memo?" "Yes, I'll be happy to." Richmond told the OIG that even though Comey did not reference the other memos in his congressional testimony, at some point during this call or a follow-up call soon after, Richmond volunteered to the Bureau that if you're collecting the one, you should get the other 3 memos Richmond had received from Comey. Richmond recalled that, at some point during these conversations, he also told the FBI that Fitzgerald and Kelly had copies of the same memos. Richmond told the OIG that there was no indication on the memos he received that there was anything classified on them. Richmond said that, after the initial conversation with Strzok, he had multiple conversations with members of the FBI about the mechanics and logistical complexities of retrieving the memos from his computer. One of those telephone calls was with Priestap and the unit chief on June 12, 2017. The unit chief told the OIG that, by that point, the FBI leaders were probably thinking of the situation as a spill of classified information, because of the sensitivity of the memos, they did not involve the FBI's security division. The unit chief said that she also learned from Richmond during that call that Comey had shared 4 memos with each of his 3 attorneys, Richmond, Fitzgerald, and Kelly. Priestap told the OIG that Richmond was courteous, cooperative, and willing to give the FBI whatever he had. Priestap also said that, by this time, the classification review of the memos had been completed at least from his end, and that he was concerned that there could be classified information contained in what Richmond received from Comey. FBI witnesses told the OIG that the FBI's plan was to have agents go retrieve a mirror copy of the hard drive and then return it to Mr. Richmond with the classified information removed. On June 13, 2017, FBI agents went to Richmond's home in New York to remove his desktop computer. On June 22, 2017, FBI agents returned the desktop computer to Richmond at his home in New York after taking steps to permanently remove the memos from it. While at Richmond's residence on June 22, 2017, the FBI agents also assisted Richmond in deleting the text message with the photographs of Memo 4 from his cell phone. The FBI also took steps, although not until several months later, to delete the memos from Fitzgerald's and Kelly's computer accounts. In response to an October 31, 2017 request from the FBI, Fitzgerald voluntarily and promptly provided the FBI with addresses and identifying information for all of the email accounts belonging to Fitzgerald, Richmond, and Kelly, to which copies of memos 2, 4, 6, and 7 had been sent. Between November 20, 2017, and January 16, 2018, FBI agents met with the individuals and IT professionals associated with these accounts, and confirmed that the emails and copies of the memos were deleted from the computer systems that had received them. V. OIG analysis. Consistent with the Inspector General Act and Department regulations, this matter was referred to the OIG in July 2017 by then-acting FBI Director Andrew G. McCabe following the FBI's determination that Comey may have shared memos that contained classified information with his personal attorneys. At the time, the OIG also was aware of Comey's June 8, 2017 congressional testimony that he had authorized a friend, who was also one of his personal attorneys, to provide the contents of one of the memos to a reporter for the New York Times. Upon completing our investigation, we provided our factual findings to the department for a prosecutorial decision regarding Comey's conduct. C. 5 U.S. C. A. App. 3 Section 4, D. After reviewing the matter, the department declined prosecution. In this analysis section, we address whether Comey's actions violated department and FBI policies, or the terms of Comey's FBI employment agreement. We determined that several of his actions did. We conclude that the memos were official FBI records, rather than Comey's personal documents. Accordingly, after his removal as FBI director, Comey violated applicable policies and his employment agreement by failing to either surrender his copies of memos 2, 4, 6, and 7 to the FBI or seek authorization to retain them, by releasing official FBI information and records to third parties without authorization, and by failing to immediately alert the FBI about his disclosures to his personal attorneys once he became aware in June 2017 that Memo 2 contained 6 words, 4 of which were names of foreign countries mentioned by the president, that the FBI had determined were classified at the confidential level. A. The memos were FBI records. Comey told the OIG that he considered memos 2 through 7 to be his personal documents, rather than official FBI records. He said he viewed these memos as a personal aid memoir, like his diary, or like his notes, which contained his recollections of his conversations with President Trump. Comey further stated that he kept memos 2, 4, 6, and 7 in a personal safe at home because he believed the documents were personal records rather than FBI records. Comey's characterization of the memos as personal records finds no support in the law and is wholly incompatible with the plain language of the statutes, regulations, and policies defining federal records, and the terms of Comey's FBI employment agreement. By definition, federal records include all recorded information, regardless of form or characteristics, made or received by a federal agency in connection with the transaction of public business. 80. This definition expressly covers any act of creating and recording information by agency personnel in the course of their official duties, regardless of the methods or the medium involved. 81. Comey's FBI employment agreement likewise acknowledged that LL information acquired by Comey, in connection with his official duties with the FBI, remain as the property of the United States of America. Comey's drafting of the memos can only be viewed as the act of creating and recording information by agency personnel in the course of their official duties. 82. Each of Comey's meetings with President-elect or President Trump took place because of Comey's official position as the director of the FBI. Comey told the OIG he did not have any type of a personal relationship with Trump. Comey's memos documented discussions, meetings, and interactions between the president and the FBI director that took place in official settings, such as the West Wing and the Oval Office of the White House, or during telephone conversations conducted on Comey's FBI telephone or FBI-issued mobile device. Further, much of the content of the memos was directly tied to FBI investigative activities. For example, Memo 2 concerned whether, at the president's request, the FBI should open an investigation into the salacious information to prove it was a lie. Memo 4 included a reference to the president's statement that he hoped Comey could see his way clear to letting Flynn go, because the president believed Flynn hadn't done anything wrong. Memos 6 and 7 concerned whether Comey, in his role as FBI director, was taking any action to lift the cloud created by the investigation into Russian interference in the 2016 presidential election. The memos also contained repeated assurances from Comey, as the FBI director, to President Trump that Trump had not been named as a subject in an FBI investigation. Comey's own statements and actions demonstrate the inherently governmental nature of the memos. Comey wrote in Memo 2 that he was attempting to recount in some detail only those parts of the January 27, 2017 dinner conversation that related in some way to his work. Comey told the OIG that at the time he wrote Memo 3 he knew it contained classified information and therefore never took a copy. Memo 3 home.A3 As Comey well knows, classified information is never considered personal property, rather, it is the property of the U.S. government. Point 84 Even if the memos contained some amount of personal information, as Comey claimed, this would not change the memo's status as federal records. The FBI's records management policy states that if a document contains both official and personal information, it must be treated as a federal record. 85 In addition, the format of the memos as emails or informal documents does not alter their status as FBI records. Under FBI policy, so long as the records are created in the course of official duties, as the memos clearly were in this case, the methods or the medium involved does not affect their status as official records. Point 86 None of the members of Comey's senior leadership team agreed with or defended Comey's view that these memos were personal in nature. Instead, McCabe, Baker, Priestap, and Rybitsky each told the OIG that they considered the memos to be records of official FBI business between the president and the FBI director. McCabe described the memos as a record of Comey's official engagement with the president. Baker told the OIG that Comey's memos were discussed in the office in connection with Comey's official responsibilities, and Priestap characterized the memos as FBI work product, produced by the director in his capacity as director. After Comey was removed, the memos were uploaded to the FBI's case management system in connection with an ongoing FBI investigation, and Rybitsky took steps to ensure that the original memos were inventoried and preserved with the rest of the director's official records. For the above reasons, we conclude that the memos are official FBI records as defined by statute, regulations, department and FBI policies, and Comey's FBI employment agreement. Because they are official FBI records, Comey was required to handle the memos in compliance with all applicable department and FBI policies and the terms of his employment agreement. B. Comey violated department and FBI policies pertaining to the retention, handling, and dissemination of FBI records and information. Comey's actions with respect to the memos violated department and FBI policies concerning the retention, handling, and dissemination of FBI records and information, and violated the requirements of Comey's FBI employment agreement. Below, we discuss these violations. 1. Comey failed to return memos 2, 4, 6, and 7 after being removed as FBI director. Comey violated department and FBI policies, and the terms of his FBI employment agreement, by retaining copies of memos 2, 4, 6, and 7 after he was removed as director, regardless of each memo's classification level. As a departing FBI employee, Comey was required to relinquish any official documents in his possession and to seek specific authorization from the FBI in order to personally retain any FBI documents. Comey failed to comply with these requirements. Under Department of Justice Policy Statement 0801.02, Removal of and Access to Department of Justice Information, the Department owns the records and information captured, created, or received during the conduct of official business. 87 Likewise, the FBI designates all official records and material as property of the United States, and requires departing employees to surrender all materials in their possession that contain FBI information upon separation from the FBI. 88 This policy is reiterated in Comey's FBI employment agreement, which specifically states that he was required to surrender, upon termination of his employment, any materials in his possession containing FBI information. A department employee who wants to retain department records or information after their employment ends must make a written request, receive approval from the appropriate official, and execute a non-disclosure agreement. 89 As the FBI director and head of a department component, Comey was required to apply for and obtain authorization from the Assistant Attorney General for Administration to retain any FBI records after his removal. 90 Comey violated these Department and FBI policies by failing to surrender his copies of memos 2, 4, 6, and 7 upon being removed as FBI director and by failing to seek authorization to retain them. Comey's explanation for his conduct was that he considered the memos to be personal records, but for the reasons previously described, this assertion is without any legal basis. In view of the clarity of relevant provisions of law, policies, and Comey's employment agreement, the assertion that the memos were personal records was not reasonable. We found it particularly concerning that Comey did not tell anyone from the FBI that he had retained copies of the memos in his personal safe at home, even when his chief of staff, the FBI's associate deputy director, and 3 SSAs came to Comey's house in May 12, 2017, to inventory and remove all FBI property. 2. Comey improperly disclosed FBI documents and information. Comey violated FBI policies and the requirements of his FBI employment agreement when he sent a copy of Memo 4 to Richmond with instructions to provide the contents to a reporter, and when he transmitted copies of Memos 2, 4, 6, and a redacted version of 7 to his 3 attorneys. We discuss these violations below. A. Comey's improper disclosure of Memo 4's contents through Richmond to a reporter. Comey told the OIG that he made the decision to provide the contents of Memo 4 through Richmond to the New York Times so that the president's request of Comey to let Flynn go would be in the public square. At the time, as Comey knew from his work as FBI director, the FBI had an ongoing investigation of Flynn that included examining Flynn's contacts with the Russian ambassador. 91 Comey said he believed disclosing the president's statement would change the game by creating extraordinary pressure on the leadership of the Department of Justice, which Comey did not trust, to appoint a special counsel who would preserve any potential tapes of his conversations with the president. Comey said his view at the time was that, if the world knew there might be tapes of Donald Trump asking me to drop an investigation, there would be tremendous pressure for the Deputy Attorney General to hand it to an independent prosecutor. Comey also said he believed that this was something he was uniquely situated to do as a private citizen, but that he chose to do this through an intermediary because he did not want to respond to questions from reporters. Comey violated FBI policy and the requirements of his FBI employment agreement when he chose this path. By disclosing the contents of Memo 4 through Richmond to the New York Times, Comey disclosed the contents of Memo 4 in an attempt to force the department to take official investigative actions, to appoint a special counsel and preserve any tapes as evidence. When asked by the OIG whether he considered that disclosure of this information would significantly affect FBI equities, Comey stated that he would frame it differently. He said he viewed the issue as one of incredible importance to the nation as a whole, and told us he felt that taking action was something I had to do if I love this country. And I love the Department of Justice, and I love the FBI. However, Comey's own personal conception of what was necessary was not an appropriate basis for ignoring the policies and agreements governing the use of FBI records, especially given the other lawful and appropriate actions he could have taken to achieve his desired end. Members of Comey's senior leadership team used the adjectives surprised, stunned, shocked, and disappointment to describe their reactions to learning that Comey acted on his own to provide the contents of Memo 4 through Richmond to a reporter. The unauthorized disclosure of this information that Comey knew only by virtue of his position as FBI director, violated the terms of his FBI employment agreement and the FBI's pre-publication review policy. Public sensitive investigative information related to an ongoing FBI investigation, information he had properly declined to disclose while still FBI director during his March 20, 2017 congressional testimony. Comey was not authorized to disclose the statements he attributed to President Trump in Memo 4, which Comey viewed as evidence of an alleged attempt to obstruct the Flynn investigation and which were relevant to the ongoing Flynn investigation. Comey clearly considered the contents of Memo 4 highly sensitive. In fact, as he stated in his June 8, 2017 congressional testimony, Comey and other senior leaders of the FBI had decided not to report the president's statements to the Attorney General or Deputy Attorney General, and to keep the president's statements very closely held, so that the FBI leadership could figure out what to do with it down the road as our investigation progressed. Comey placed in the public domain evidence relevant to the investigation of Flynn, and what he clearly viewed as evidence of an attempt to obstruct justice by President Trump. Rather than continuing to safeguard such evidence, Comey unilaterally and without authorization disclosed it to all. By his own admission. B. Comey's improper disclosure of Memos 2, 4, 6, and 7 to his attorneys. Comey told the OIG that he shared copies of Memos 2, 4, 6, and 7 with his attorneys to obtain legal representation in connection with his removal as FBI director and any post-removal legal issues that might arise. However, Comey was not authorized to provide these memos to his attorneys without prior approval from or coordination with the FBI. As courts have made clear, a federal employee seeking legal advice does not have carte blanche authority to disclose any and all confidential government information to the employee's attorney. 95 Rather, Comey's interest in communicating with his counsel must be balanced against the government's legitimate interest in protecting its information and preventing disclosure of certain types of information, such as National Security or Privacy Act protected information. 96 To strike this balance, courts have fashioned protective orders and required private attorneys to sign non-disclosure agreements. Courts also have placed restrictions on the employees or former employees' further distribution of government information through an attorney in order to prevent any de facto public disclosure. 97 The United States Supreme Court has also recognized the validity and enforceability of employment agreements, like the one signed by Comey, which require a public employee to submit to the pre-publication review process before making disclosures. 98 By providing Memos 2, 4, 6, and 7 to his attorneys without seeking FBI approval, Comey took for himself the carte blanche authority, expressly denied by the courts, in clear violation of the FBI's pre-publication review policy and the requirements of Comey's FBI employment agreement. 99 As a result, Comey not only disclosed sensitive law enforcement information to his personal counsel but also a small amount of information contained in Memo 2 that the FBI subsequently determined was classified at the confidential level. C. Comey failed to immediately alert the FBI to the unauthorized disclosure of classified information. On June 7, 2017, Comey learned of the FBI's classification decision regarding Memo 2 when the FBI allowed him to review copies of all 7 memos, with classification banners and markings, in preparation for his June 8, 2017 congressional testimony. Once he knew that the FBI had classified portions of Memo 2, Comey failed to immediately notify the FBI that he had previously given Memo 2 to his attorneys. 101 The FBI's Safeguarding Classified National Security Information Policy Guide clearly states that a NY person who has knowledge that classified information has been or may have been lost, compromised, or disclosed to an unauthorized person must immediately report the circumstances to his or her security office. 102 Comey violated this requirement by failing to immediately inform the FBI that he provided Memo 2 to his attorneys. The FBI did not learn that Comey had shared any of the memos with anyone outside the FBI until Comey's June 8, 2017 congressional testimony. During his testimony, Comey stated that he provided Memo 4 to a friend to share the contents with a reporter. Comey did not mention that he provided Memos 2, 4, 6, and 7 to each of his 3 attorneys. Based on Comey's testimony, FBI leadership knew that Richmond was the friend to whom Comey had disclosed Memo 4 with instructions to provide its contents to the New York Times. Baker and Strzok immediately called Richmond, while Comey was still testifying, to make arrangements to retrieve Memo 4. It was only through the FBI's conversations with Richman on June 8 or June 9 that the FBI learned of the need to retrieve classified information contained in Memo 2, as well as other FBI records, Memos 6 and 7, from each of Comey's 3 attorneys. We do not believe that Richman's volunteering to the FBI that he and Comey's other counsel had these other memos, after the FBI initiated contact with Richman in an effort to retrieve Memo 4. Fulfilled Comey's obligation to immediately report his disclosure of classified information to unauthorized persons. By not immediately reporting that he had provided Memo 2 to his attorneys when Comey first learned that the FBI had designated a small portion of Memo 2 as classified at the confidential level, Comey violated FBI policy. V. Conclusion. Congress has provided the FBI with substantial powers and authorities to gather evidence as part of the FBI's criminal and counterintelligence mission. The FBI uses these authorities every day in its many investigations into allegations of drug trafficking, terrorism, fraud, organized crime, public corruption, espionage, and a host of other threats to national security and public safety. In the process, the FBI lawfully gains access to a significant amount of sensitive information about individuals, many of whom have not been charged, may never be charged, or may not even be a subject of the investigation. For this reason, the civil liberties of every individual who may fall within the scope of the FBI's investigative authorities depend on the FBI's ability to protect sensitive information from unauthorized disclosure. As Comey himself explained in his March 20, 2017 testimony before the House Permanent Select Committee on Intelligence, he was unable to provide details about the nature or scope of the FBI's ongoing investigation into Russian interference in the 2016 presidential election because the FBI is very careful in how we handle information about our cases and about the people we are investigating. Our ability to share details with the Congress and the American people is limited when those investigations are still open, which I hope makes sense. We need to protect people's privacy. We just cannot do our work well or fairly if we start talking about it while we're doing it. However, after his removal as FBI director 2 months later, Comey provided a copy of Memo 4, which Comey had kept without authorization, to Richman with instructions to share the contents with a reporter for the New York Times. Memo 4 included information that was related to both the FBI's ongoing investigation of Flynn and, by Comey's own account, information that he believed and alleged constituted evidence of an attempt to obstruct the ongoing Flynn investigation. Later that same day, the New York Times published an article about Memo 4 entitled, "Comey Memo Says Trump Asked Him to End Flynn Investigation." The responsibility to protect sensitive law enforcement information falls in large part to the employees of the FBI who have access to it through their daily duties. On occasion, some of these employees may disagree with decisions by prosecutors, judges, or higher-ranking FBI and department officials about the actions to take or not take in criminal and counterintelligence matters. They may even, in some situations, distrust the legitimacy of those supervisory, prosecutorial, or judicial decisions. But even when these employees believe that their most strongly held personal convictions might be served by an unauthorized disclosure, the FBI depends on them not to disclose sensitive information. Former Director Comey failed to live up to this responsibility by not safeguarding sensitive information obtained during the course of his FBI employment, and by using it to create public pressure for official action. Comey set a dangerous example for the over 35,000 current FBI employees, and the many thousands more former FBI employees, who similarly have access to or knowledge of non-public information. Comey said he was compelled to take these actions. "If I love this country, and I love the Department of Justice, and I love the FBI." However, were current or former FBI employees to follow the former director's example and disclose sensitive information in service of their own strongly held personal convictions, the FBI would be unable to dispatch its law enforcement duties properly, as Comey himself noted in his March 20, 2017 congressional testimony. Comey expressed a similar concern to President Trump, according to Memo 4, in discussing leaks of FBI information, telling Trump that the FBI's ability to conduct its work is compromised if people run around telling the press what we do. This is no doubt part of the reason why Comey's closest advisors used the words surprised, stunned, shocked, and disappointment to describe their reactions to learning what Comey had done. We have previously faulted Comey for acting unilaterally and inconsistent with department policy. 103 Comey's unauthorized disclosure of sensitive law enforcement information about the Flynn investigation merits similar criticism. In a country built on the rule of law, it is of utmost importance that all FBI employees adhere to department and FBI policies, particularly when confronted by what appear to be extraordinary circumstances or compelling personal convictions. Comey had several other lawful options available to him to advocate for the appointment of a special counsel, which he told us was his goal in making the disclosure. What was not permitted was the unauthorized disclosure of sensitive investigative information, obtained during the course of FBI employment, in order to achieve a personally desired outcome. The OIG has provided this report to the FBI and to the Department of Justice Office of Professional Responsibility for action they deem appropriate.